Court is now in session. The Honorable Matthew Hoffman presiding. As always, there'll be no talking while His Honor is on the bench. Now you may be seated.
All right. Good morning.
Morning, Your Honor.
All right. I understand there's a matter to take up outside the presence of the jury.
Yes, Your Honor.
All right.
Jeffrey Bright, Your Honor, for the record. Your Honor, we advised the court, and the court urged us at the beginning of this trial to make sure that we had agreement with counsel and urging the court at 7 o'clock each evening, we would provide the witness list for the next day. Defendants in this case have subpoenaed 42 witnesses, and they have asked virtually every one of our fact witnesses to be reserved for trial. Last night at 7 o'clock, we advised the court early and counsel that we would be finished either Wednesday afternoon or Thursday morning. No surprise. The defendants last night gave us one witness for today, and that's a witness who's already testified, Officer Blythe. I know that they have their own strategy to keep, but they've now told us their experts are unavailable till Monday. There are at least 35 local witnesses here in Newport News that are under subpoena. And I'm just wondering, like, what's happening with one witness when we're trying to do an efficient trial? I would have thought their experts would have been here no later than tomorrow, at worst. Now they've given us one witness and reserving 41 witnesses. So I think the court needs to understand that, what are we going to just go home and do nothing until Monday, or are they going to wait and hold 20 witnesses tomorrow? So I'm of great concern that we are wasting a huge amount of judicial time as well as counsel time, and that is my concern. Officer Blythe, we have other issues with, but we'll bring it up after they start their case.
All right. All right. Were you not able to provide a schedule for witnesses?
We did provide. I'm going to let Mr. Hogan address the issues about the fact witnesses. I want to address the scheduling. We asked months ago when we would get the case. We've been told repeatedly midday on Friday, and we planned accordingly. I made the court aware very early on that our experts were coming on Monday, so that there's nothing new here. They significantly truncated their case, and we have not heard the testimony of the day, which largely depends on, will change what fact witnesses that we call. So I'm going to let Mr. Hogan address that.
Yes, Your Honor, may it please the court. With respect to the fact witnesses, I'll note Mr. Bright is correct that there are several witnesses on deck. And they may be necessary to rebut or challenge the testimony that develops today. Also, as Ms. Douglas has alluded to, this case has been fluid from the beginning, although we have received assurances throughout that it was likely that we would receive the case by Friday. To the extent that there's an inconvenience to these witnesses, I've been in close coordination with them. I've kept them apprised of the proceedings throughout, and so depending on how the evidence shakes out today, I can also confer with counsel at the end of today, and we can make a decision and give them notice about who to expect tomorrow. If I'm not trying to keep anybody on the hook and keep them in limbo without, I'm not trying to unduly inconvenience people. I'm sensitive to that fact, Judge. But these folks, we can't control the way the evidence develops or some of the calendaring issues. So.
All right. Yeah, I've understood about the experts. I'm assuming they're coming from other places other than here, and that those travel arrangements had to be made ahead of time, and that was your best guess for Monday. And you've told the court that when we started that, so I don't have any problem with that. I'm just hoping that we can get in as many fact witnesses on the defense side on Friday, and I understand the need to wait to hear what the testimony is today to then decide, but I am going to ask that, by the end of court today, I'll give you some time after we're finished with the witnesses that we talk about another scheduling time for and how many witnesses you think you can call either this afternoon or for Friday. All right, so I'll withhold any decision on that or taking any action, I will say. Okay. All right. Are you ready to call your next witness and have the jury come in?
Yes, Your Honor.
All right. Very well. All right. You may bring in the jury.
in the box.
Press pull. No, you're all right. Wait, pull. All right. Good morning, ladies and gentlemen. All right, we are going to proceed with the plaintiff's next witness.
Dr. Clarence Watson.
Let me get you stand here, face the clerk, raise your right hand.
Do you swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
This way. Watch your step, stepping up.
May it please the court.
You may proceed.
Good morning, Dr. Watson.
Good morning.
Could you go ahead and introduce yourself to the jury and state your full name for the court reporter?
Yes, my name is Dr. Clarence Watson. Clarence Watson.
And you're a doctor in what?
Psychiatry, forensic psychiatry.
And doctor, you're here today because at some point we had asked you to evaluate our client, Miss Abigail Zwerner. Is that correct?
That is correct.
And you, as a result of that evaluation, have come to some findings as it relates to her psychiatric condition. Is that correct?
That is correct, yes.
And we'll get to that during your testimony. But we have to sort of check some boxes before we can get there. We can go to the IPVO. And so this is a little roadmap of what we'll be talking about today, okay?
Okay.
We're going to talk about you to start. We'll talk about your experiences. Then we'll talk about the evaluation itself of Mrs. Zwerner. Then I want to talk to you about this brain-body concept that may come out in that evaluation.
Yes.
And then I want to talk to you about your view and your prognosis for Miss Zwerner's future. Sound good?
Yes.
All right. So let's talk about your experience. You said you're a doctor in psychiatry. Can you walk us through your educational background that led to that DR in front of your name?
Sure. So I started on a different path. I started out my undergrad degree at Temple University in Philadelphia, where I earned an economics degree. At the time, I was deciding between medicine and the law, and I decided that law was quicker.
My condolences.
So I went to law school. After undergrad, I graduated from Villanova School of Law. And then I decided that I was not done with this sort of science bug and the medical, my interest in medicine. And so I went into a post-bac program to take prerequisite courses to allow me to apply to medical school and successfully completed that. And then went on to Jefferson Medical College, where I graduated from medical school. After that, I went into internal medicine at Thomas Jefferson University Hospital, did my internship there, and then thereafter switched to general psychiatry and completed my residency in psychiatry at Thomas Jefferson University Hospital. Following that 4-year period, I then went into forensic psychiatry training in New York at St. Vincent's Hospital, the New York Medical College.
And could you talk to us about the distinction or the difference, if any, between general psychiatry, the 4 years, and then what you do in the 2 years of forensic psychiatry training?
Sure. And the training for forensic psychiatry fellowship program is 1 year. And so it's a total of training in psychiatry for me of 5 years. And the general training is learning everything that you need to know about mental health disorders. And so that spans across all age groups and genders. It expands across all mental health disorders, anxiety disorders, depressive disorders, psychotic disorders, developmental disorders in children and adolescents, geriatric issues and problems as well. And so that training involves treating individuals with these mental health disorders, these populations, providing care for them and follow-up in different settings, sometimes in outpatient settings, sometimes in inpatient settings. And after completing that, I went into forensic psychiatry, and the difference there is that you learn how to apply your general understanding of psychiatric disorders in legal situations where a legal question is posed. So that might be in cases similar to the case today in civil lawsuits. It could also be involved in criminal cases around issues of mental state at the time of the offense and competence to stand trial.
And as part of those two areas of psychiatry, first we're talking general psychiatry and then forensic psychiatry, is there a board certification process?
Yes,
And are you board certified in general psychiatry?
I am.
And are you board certified in forensic psychiatry?
Yes.
And could you tell us just briefly what it means to be board certified in those fields?
Sure. What that means is that after your training, well, first you have to have all the requirements to be able to sit for a board examination, and that you've completed that successfully, and then you meet all of the standards in which is tested through examination to adequately go treat individuals in the community around mental health disorders. So there's a test you have to pass to be board certified, and there's a stamp of approval that is given to you in those specialties.
And since you received that stamp of approval, have you been applying those both general psychiatric and forensic psychiatric skills and lessons?
Oh, yes,
And,
every day.
And tell us about your clinical experience from the time of education to present.
Yes. So after my training in New York, I returned to Philadelphia, where I worked on the inpatient psychiatric unit at Thomas Jefferson University Hospital. I continued my work there, also in outpatient treatment for individuals who were not admitted to the hospital, but had mental health disorders and difficulties in the community. After that, I moved on to oversee the forensic psychiatry. There's a forensic building program in Delaware, a maximum security forensic unit where individuals with criminal justice involvement they're admitted there on an inpatient basis. And so I provided clinical care for those individuals, treating those folks who were in the Department of Corrections and destabilized there and needed to be stabilized and returned to prison, individuals who were found not competent to stand trial and then received treatment to restore their competence, and other individuals who were ordered there by the court because of mental health problems related to their case. Making sure that those individuals will be able to be adequately treated and then transferred to prison to set out the rest of their services. As I continued on in terms of my clinical practice, I eventually made my way back to Pennsylvania from Delaware, where I became the statewide forensic director overseeing the 2 state forensic hospitals in Pennsylvania. In that capacity, I handle complex psychiatric cases, overseeing the psychiatrists and physicians who treat those individuals. I also become involved in treatment interventions, reviewing those cases for efficacy of treatment, making recommendations, and then overseeing that treatment to be sure that those individuals were actually responding positively to the treatment.
And in that, through that clinical practice, in addition to that, do you have any academic appointments presently?
Yes, I am. I've been appointed clinical professor of psychiatry at the University of Pennsylvania.
And can you just briefly tell us what that means in terms of your workload and balancing the other stuff we've talked about?
Sure. So my faculty appointment at the University of Pennsylvania allows me to train psychiatrists or doctors at various points in their training and career. So there might be medical students, it could be psychiatric residents, it also could be fellows, so folks who have completed their psychiatric training and then they move on for subspecialty training like I did in forensics. As a part of my work there, I'm also the director of the Forensic Psychiatry Fellowship Program at Penn. So I train psychiatrists to do the work that I'm doing today.
And doctor, throughout your experience, this is a presumption, but I want you to confirm it, that you've been exposed to post-traumatic stress disorder.
Yes, regularly.
And you've clinically diagnosed it in other people.
Yes.
Correct?
And treated
you've-
it, yes.
You've seen how it develops over time, chronic and acute.
Yes.
You've encountered anxiety disorders and depressive disorders.
Yes.
And you've encountered essentially these manifestations that we may be talking about today in Ms. Zwerner and other people throughout your both clinical, educational, and academic settings.
Yes, that's true.
Doctor, I now tender Dr. Watson as an expert in the fields of general psychiatry and forensic psychiatry.
Any objection to that?
No objection.
Right, he'll be so qualified.
Dr. Watson, I'm going to ask you about the evaluation now. And as we go through it, I may be asking you for your findings or your opinions as we go through them. Will you agree only to offer those if you hold them within a reasonable degree of medical certainty?
Yes.
Okay. So, at some point in time, we contacted you in order to perform an evaluation of Ms. Zwerner, excuse me. Is that right?
That's correct.
Can you walk us through the process that you followed in order to conduct the evaluation and then come to your findings that you're sharing with us today?
Yes. So the evaluation started out with a discussion with your office about the case in general, receiving a summary of the case and learning more about the complaint in the case. At that point, determining whether or not my expertise is something that I would be able to lend to the case in one way or the other after I learned more about the case. Once the decision was made that that would work, then we went about having me receive records related to Ms. Zwerner's history, her the incident that brings us here today, her medical records, and once I received those, then it was a matter of scheduling a meeting with Ms. Zwerner, and we were able to accomplish that. I met her on 2 occasions, one in person, and that was in my office in Pennsylvania in October, I want to say October 2024, and we met there for about 4 hours. And then I later saw Ms. Zwerner this summer at some point, I want to say maybe in July of 2025. And that was after receiving additional records that I did not have earlier on for issues that Ms. Zwerner had in between our evaluation times. After that, I prepared a report and then submitted it to your office.
Now, Dr. Watson, you mentioned previously that you had records that included medical records in her history.
Yes,
And when we say history, we're talking about before January 6, 2023.
that's correct, yes,
And then we're also talking about records since January 6, 2023.
that's correct.
And that included, her primary care doctor and some therapy records as well, correct?
Yes,
And you used those to gather information, and then you sat down with Ms. Zwerner, as you talked about.
that's correct.
What's the importance or significance of actually sitting down with somebody when you're performing a psychiatric evaluation of them?
Well, it's important to sit down with the individual if you are planning on reaching a diagnosis for that individual. And so reviewing the records alone is not sufficient. Sitting with an individual to evaluate them and ask them about their experiences, their symptoms, and observing their behaviors and their description of those experiences is important objective information. So part of the psychiatric examination is to observe the individual as they are sharing information about their symptoms. And the longer that you have with the individual to be able to do that, the better. And so with that, matching up whether or not what you are seeing in person and what they report to you in person is consistent with what you find in the records. And so that's why it becomes important.
And doctor, when you are going through this evaluation process for Ms. Zwerner, when you came to your final conclusions and opinions, did you have enough materials and information for you to make that clinical finding?
Yes.
That diagnosis?
Yes.
And can you share with us first what the diagnosis is, and then we'll break that down and explain how and why we got there?
Yes. The diagnosis is post-traumatic stress disorder, as well as a history of a depressive disorder and history of anxiety disorder.
So when you say history, and we sort of called on that word a little bit before, is part of your evaluation to try and determine whether somebody has had any experience in their life before the, what we'll call, incident event?
Yes.
And why is that important?
Well, whenever conducting any psychiatric examination, you have to have a life course to understand where the person is today. And so to simply start off with where they are today is not sufficient. You have to start off way back to see what the source of the person's symptoms happens to be today. So the examination really begins with birth. The evaluation goes back, gathering all sorts of information about developmental history, whether or not there have been traumatic experiences in that person's life up to that point, whether or not that person has a family history that makes them more prone because of genetic predisposition for certain mental health disorders, whether or not that individual has other factors that may be influencing their behaviors and the symptoms. For example, is that person using substances, an addiction? Are those addictions actually more likely to be responsible for a person's symptoms than something that they're reporting? Has this person been abused in the past? How long did that abuse go? And so really diving into all of the things that might impact a person's today presentation becomes important. So looking at these historical factors gives us more ability to put into context what we see today.
And in your evaluation of Ms. Zwerner's history, were there any findings or observations that became relevant to your ultimate conclusions?
Yes.
Can you explain what those were?
Sure. Well, so I will start with, if I'm thinking about well, first I will start with the very early positive factors in Ms. Zwerner's life. And so she had a very positive upbringing. Not very traumatic in terms of her history. When she was surrounded by a very positive family, loving family, supportive to her and her needs and encouraging her in terms of her career and focus. There were no issues around substance use disorders or other problematic childhood developmental disorders. So all of that becomes very important background. There was nothing in terms of growing up with domestic violence or sexual assaults, sexual abuse, no childhood neglect. So we first start with that backdrop. And then noting when there appeared to be maybe some difficulty, some emotional changes and such. And so the first time in terms of the records that I had available to me was somewhere around 2018 where she started to, I believe it was 2016, when she started to express to her family physician that she was at least experiencing some depressive symptoms. At that time, not anything that raised anything major, but she at that time had a transition in life, and that was she was in college, a freshman, dealing with the stresses of being a college student. At some point, though, later on, 2018, the stress of college started to become a little bit more difficult, and her family physician treated her for depressive symptoms and anxiety symptoms. Those symptoms being tied to the stress of her academic activities, and that was clear in the records. What was also clear in the records was that even though she was having those symptoms, she was able to continue to function and was functioning relatively well. She was pursuing her degree and completed that successfully. She was she was actively social, had friends, did things, exercised regularly. And so she was overall doing well and was being managed well with her family physician in terms of her treatment. Unfortunately, she then had a traumatic experience, one that I think many of us could relate to, which was a loss of her father unexpectedly in 2020. And of course, that was a traumatic experience for her and her family. And there was a period of grief and some difficulty around that grief. And fortunately, she was able to receive some grief counseling to get her through that period of time. She was also able to continue to start her work as a teacher shortly thereafter. As a matter of fact, if I'm remembering correctly, I want to say that her father passed away in, I want to say, July of 2020, I believe, that summer at least. And then she was starting work in that fall. And she was able to do that despite her difficulties around losing her father. And the medical records were very good in documenting her progress during that time, her treatment, and her eventual improvement around the stresses related to that. So those were the major events, including the stress of being a brand new teacher and starting career after college, those sort of things, until we come to January 6th of 2023. I should note, though, that despite some of the symptoms related to her depression and anxiety leading up to that point, and it was very clear in the medical records that she was doing well and had a lot of improvement leading up to January 6, 2023. The records show that she pretty much had mild, if any, symptoms and was doing well overall.
And in terms of the timeline as you've laid out, the loss of her father, 2020, this event, January of 2023, is it, in your review of the records, did it appear that the grief was under control?
Yes.
And that she was operating and going out and returning to her normal self, if we call it that way?
Well, yes. I mean, even with the grief of her father closer to, his death, she was still involved in social activities. She was still involved in family activities. She was still very active, was not withdrawn, not isolative. She was not overwhelmed to the point where she was impaired in her normal functioning at that point.
So I want to transition now and talk about how, if at all, in your findings that changed as a result of January 6, 2023. So we mentioned the diagnosis of post-traumatic stress disorder.
Yes.
And if we can just briefly explain to the jury so that it may help us frame it for them. The post-traumatic stress disorder is a condition that's explained in the DSM-5. Is that correct?
That's correct, yes.
Could you tell us briefly what the DSM-5 is, what that means?
Sure. So the DSM-5 stands for the Diagnostic and Statistical Manual of Mental Disorders. It's a 5th edition now, and there's a later text revision really refining the definitions around specific mental health disorders. And it is the primary text that mental health clinicians use to reach diagnoses so that we are all understanding the same language when we meet a patient and we diagnose that patient. It guides our treatment approaches to make sure that we're able to select the proper treatment for the individual given the collection of symptoms that they're exhibiting at the time. And so the DSM for short is really our guide to diagnosing and treating patients with mental health disorders.
And what I have on the screen for us to look at is different letters. So we have post-traumatic stress disorder, A, B, C, D, E, and F. Are you able to see that?
Yes.
And I've given them little subheadings. Are these subheadings sort of part, I know they're simplifications, but are they simplifications of what that guide tells you as a clinician in the field of psychiatry to look for if and when diagnosing post-traumatic stress disorder?
Yes, although there's one missing, and we can talk about that.
Go ahead and let's put it on there before I forget about it. What is that one?
All right, so let's see. We can put it between C and D, avoidance. So we can call it whatever, C and a half or something you want to call. So that would be negative alterations in mood and cognition. And then D technically would be what we call alterations in arousal and reactivity.
All right. With those tweaks, is this a simplification of the guide that you walked through in this instance as it relates to Ms. Zwerner's diagnosis of post-traumatic stress disorder?
Yes.
So talk to us about subsection A, traumatic event.
Yes. So the DSM, the criteria for post-traumatic stress disorder, requires that there is exposure. A person is exposed to actual or threatened death, serious injury, or sexual violence.
And in your evaluation of Ms. Zwerner, obviously we've talked about the facts of this case, but was there any reporting from her to you about her perceived risk of death?
Yes.
Can you tell us about that?
Well, she believed that she was dying, that someone was trying to kill her, and that they had successfully made that attempt, and she was attempting to survive, and she was bleeding and had difficulty breathing and panicking, believing that that individual was following her and was going to finish the job.
And in your review of her evaluation, does that check the box, so to speak, as it relates to the traumatic event?
Absolutely. It's almost, I mean, that's sort of a classic trauma.
So let's talk then about the re-experiencing or re-experienced. Tell us what that means in your world.
Sure. So what that means is that a person is what we call in DSM intrusive symptoms. So either there are distressing memories, distressing nightmares, distressing re-experiencing of events that related to the trauma that are intrusive. In other words, you're not actively thinking about the trauma, but it inserts itself. It pushes itself into your consciousness, even when you don't want it to, right? And so this is when you hear folks say, they've suffered flashbacks, for example, or they say that they had nightmares about the event or something similar to the event, right, in which they are in danger, and sometimes it is very specific and a reminder very clearly of imagery around the trauma itself. Sometimes it's not that. There are times where a person is in a nightmare where they are fearing their death or being attacked, and they're running and they're trying to escape something, and maybe it's not as clear. But the clear piece about this is that those nightmares happen, or those intrusive events happen after the trauma. You don't expect to see those sort of things before. And so you look and say, okay, after the trauma, this person is suddenly having these distressing nightmares in which they're in danger. And they're related and associated with the traumatic event itself.
And in your evaluation of Ms. Zwerner, did she report having nightmares?
Yes, she did.
and you talked about some of these nightmares being specific and some of them being more general. How
Yes.
would you categorize Mrs. Werner's reports of her own nightmare?
Her reports were more specific, yes. So she had some dreams that were related to being, feeling like she was not safe. But generally, she had dreams about the student who shot her. She had dreams about the student's expression, facial expression, as a blank stare as he pulled the trigger. She had dreams about being in the school and the student being there. No one else is in the school, and the student following her, and she tries to escape, and then he finds her in a closet somewhere while she was hiding. She had another nightmare about another student who somehow, I think, was involved in one way or the other, but that student was harmed, and so this gruesome sort of imagery in which that student was found dead. And so her sleep had been disturbed by the pressing of the psychological distress that she's under, thinking about this trauma or dealing with this trauma, that it pushes into even her dreams. And this is how we understand those nightmares.
And you mentioned earlier that your more recent discussion and sit down with Ms. Werner was in July of this year.
Yes.
And in July of this year, did she report whether those nightmares were still occurring?
Yes. I want to say that I think she said something along the lines of over the previous few months, she had at least 3 of those nightmares.
And when we talk about having intrusive symptoms and these coming to her in the night, and you mentioned intrusive is, even when you don't want them to.
Right.
What-
When something's your attention's not necessarily distracted. You could be driving down the road, and then this comes to you, and you're re-experiencing having a memory of this traumatic event, and usually with that comes a physiologic response. Right, a person starts to feel some degree of heightened anxiety. Heart might be racing. In Ms. Werner's case, she felt shallow breathing, body heaviness, and racing, heart racing palpitations. These are the sort of things that you would expect.
And we talked earlier in your roadmap about the brain and body.
Yes.
Is this physiological response part of what happens when you have a condition like post-traumatic stress disorder?
Yes. We tend to have this artificial division between the brain and the body. It's all connected, right? So all of us are sitting right here. Our brain right now is keeping us alive, right? You're not thinking about your heart beating, but guess what? Your brain is making it happen, right? You're listening to me right now. There are all sorts of things that you might feel. Something, if you have your own traumatic experiences, might remind you of something. You might feel a little anxiety and such, right? Viscerally, you can feel it. It's not just thoughts. And so for individuals who are suffering from severe post-traumatic stress disorder, this becomes a real thing that can even be paralyzing for individuals who feels like they have to freeze, they can't move. They're in such fear state, right? So even if rationally they say, I'm not in danger right now, I can continue, the body might respond as if there is a real imminent threat, and then your body goes into a fear response physiologically. It prepares for danger. And so this is where we talk about the shallow breathing, the heart racing, and she might be just sitting watching television, and this comes to her.
And that may be, and you tell me if I'm right or wrong, but is that what leads us, and let me start here, re-experiencing that in the guidebook was found
Intrusive, yes.
found in your evaluation?
Yes.
And when we talk about how these things can be sometimes even paralyzing, does that relate at all to the next finding as it relates to avoidance?
Yes. So because of the re-experiencing, there are times where you might not be just sitting and not doing anything, and then it comes to you, and these negative memories related to trauma come to you. But there are situations in which they may be triggered by specific reminders in your environment, and then it takes you to those intrusive thoughts, right? So you're sitting and you have this trigger that is a reminder. Let's just say for Ms. Zwerner, one of her triggers happens to be seeing individuals with their hands in their pockets, right? What are their hands doing in their pocket? Well, the last time she was in danger, real danger, and her life was threatened, someone held their hands in their pocket for a very long time before she was shot. And so seeing individuals in the community or large crowds or something like this may be triggering to the point that you have a re-experiencing of these this earlier traumatic event. And so to avoid that, as we all try to do, avoiding things that make us feel uncomfortable or distress us, then for Ms. Zwerner, the avoidance symptoms will be, I'm going to avoid those things that will cause me psychological distress. So I'm going to avoid schools. I'm going to avoid watching television shows that have classroom settings. I'm going to avoid looking at news reports of school shootings. I'm going to avoid crowds. I'm going to avoid people who have their hands in their pockets. And so those avoidance behaviors, anything that an individual does, I'm not going to go anywhere near the school where I was once upon a time shot, right? All of those things would meet that criterion for avoidance.
And so in your evaluation, Dr. Watson, did Ms. Zwerner meet that criterion of avoidance?
Definitely, yes.
Now, C2, one I forgot, negative alterations in mood and cognition. Tell us what that means and how you observed that appearing in Ms. Zwerner.
Yes, and these two, the negative alteration in mood and cognition, and increased arousal, the alterations in arousal and reactivity, they're very important, especially in Ms. Zwerner's case, when we talk about her history. So apart from those first two criteria in the DSM, they are very clearly connected to and associated with the traumatic event itself.
And when we say first two, you're talking
Right.
re-experience.
B and C, yes, exactly. So those experiences occur after the event. The negative alterations in mood and cognition and increased arousal, the alterations in arousal and reactivity, recognizes the criteria for DSM, recognizes that a person might have already had issues with depression or anxiety earlier on. And so the wording of it within the DSM goes something like, the person now has increased or negative alterations in mood, like depression or anxiety or negative thinking, that begins or worsens after the event. So you don't need to be clean before you reach this particular diagnosis. When I say clean, I mean no history of mood problems. It means that those symptoms actually worsen, if you had them, after the fact. And that would include depression, that would include anxiety symptoms, that would also include ideas and thoughts about oneself and their self-worth, their self-esteem, a sense of control or losing control in one's life. All of those things would fall into C2.
And so when we're talking about C2 and D, if I were to say, let's think about it as a small campfire that me and Keith could keep us warm, and that's life's experiences before January 6th. How would you describe what happened on January 6th as it relates to that campfire?
Well, that would be like throwing gasoline on top of the fire, right? So you have a campfire that's there, maybe the campfire is under control. then someone comes along and they throw, gasoline on it, and gasoline just splashes everywhere. So now you have the fire that is spread and burning in areas that it didn't burn before. So not only is the flame itself more intense, it becomes out of control. It starts to burn areas that were not burnt before, and it makes it more difficult for that individual who is experiencing that gasoline douse to get those feelings under control.
And in your evaluations of Miss Zwerner, did she report to you any feelings of feeling like life was out of control?
Yes. As a matter of fact, that was one of the things for her that really increased her depressive symptoms, right? The idea that there was uncertainty now in her life. She doesn't know where her life is going. And, there are times when we talk about the alterations in cognition, that would fall into that idea, right? The sort of what we call foreshortening of a person's future. Right? They don't know what's going to happen. Once upon a time, they could see. They could have ideas about what's going to happen. Now, they don't even trust their own thinking about what their future will hold because this traumatic experience has happened to them.
And when we talk about areas of the forest that are burnt, right? Areas of their life that are burnt that weren't burnt before. Can you talk to us about what those areas in your observation are in Ms. Zwerner's life now that before January 6, 2023 were untouched, unaffected?
Oh, yeah, sure. So right off, socially, she has lost the sense of being safe. Something that she had not experienced before, even when she was feeling depressed or anxious. She was anxious about certain things. She was anxious about stress here or at work or at school or something like this. But she felt safe. She felt safe to go to events where other people were. She felt safe to be around other people. She now doesn't want to go anywhere. She became socially withdrawn and isolated, pulled away from friends, didn't want to be in public as much, and felt fear in places that she didn't feel fear before, like the grocery store, feeling that she has to bring family members or friends along with her, so as support. The other piece was that her occupational functioning. This event had made her deal with such overwhelming distress about being in the classroom that she doesn't feel that she can go back to a classroom setting. She doesn't feel safe there, right? And one can imagine why, right? You're sitting in a classroom teaching, first graders. The last thing you're expecting is one of the first graders is going to pull out a gun and try to kill you. And so it makes sense that, especially when we go to the earlier criterion, that she will want to avoid such situations. Well, because she wants to avoid something that's so distressful, like the setting in which she was almost killed, then in her case, it requires her not to return to the classroom and lose her occupational functioning. She can't function in the way that she did once upon a time when she had depression before she could go to work, and she did go to work, and she was successful at it.
And when you talk about these alterations in mood and avoidance, if we heard that Ms. Zwerner went to a concert with family, are you saying that this means someone shouldn't go and shouldn't be able to go at all? Or is it just that when they go, something happens to them?
Sure. So what that means is that there will be times where a person might be able to do something, but they're experiencing something that they would not have experienced before, right? So number one, if she has to go with family and friends for support, that's something that she didn't feel like she needed before. She needed that support. She is not going back to a concert in the way that she once upon a time went to a concert. Now she is experiencing symptoms related to hyper arousal, where you become more hyper vigilant. You're feeling as if you are in danger, always looking, always watching, always scanning whether or not an individual near you might cause some harm. Why is this person looking different than the rest? Now you're keying in on one person in the crowd and watching that person instead of enjoying the concert. You're wondering whether or not this person is doing a little bit too much. Now I'm distracted thinking more about these negative things than enjoying whoever it is that I've come to see. And of course, depending on where a person is in treatment, that's a good thing. As a clinician, I want my patients to try. I want my patients to see if they can. I want them to try to get better, to see and test the bounds, because that means they want to get back to their lives. They don't want to just sit home and sit in their symptoms and cut their lives off. You know, when I met with Ms. Zwerner, it was very clear to me that she wanted to get to a place of normalcy again, where she can go to concerts and such. So the only way to be able to see how she's able to do that is to be able to, have these experiences to try.
And in your review and evaluation of Ms. Zwerner, these two criterion that we've identified as C2 and D, were those met?
Yes.
My understanding of duration is that it's maybe not a whole different thing, but it talks about how long these different symptoms are going on. Is that fair?
That's correct, yes.
So tell us about how duration appeared in your evaluation of Ms. Zwerner.
Yes. So in order to meet the criteria for post-traumatic stress disorder, the symptoms, the other criteria that we talked about, have to be present for at least a month. Now, this is actually a very important point now that I think about it, is this, is that within days of the event of her shooting, she was seen by psychiatry in Riverside Regional Medical Center through a psychiatric consultation within days. And that psychiatrist evaluated her and listed right away many of the symptoms that we're talking about here today. She was experiencing almost immediately. But the problem, it's not a problem. The proper diagnosis was reached at that point. And that proper diagnosis was acute stress disorder. Because if it's under 1 month, you cannot officially diagnose it as post-traumatic stress disorder. Even though all of the symptoms related to a post-traumatic stress reaction happens to be there, you have to be able to meet that, the letter, the criterion E for duration. So she was already recognized as on her way to developing post-traumatic stress disorder at that early point. And because of that, that doctor in those records made recommendations for future treatment in PTSD because it was anticipated that she would in fact develop it.
And in your review of the records, has Mrs. Zwerner been diligent in trying to get help for what's happened?
Yes, as a matter of fact, I've been very impressed. She not only has been seeking and continue to seek treatment with her family physician, who she had been receiving treatment. I mean, he was a family physician for a very long time, so knew her when she was having her earlier depressive symptoms to now, and so continue with that. Also continue with, I want to say, the therapists are through Abundant Life Partners, I think is what it is, where she's seen 2 therapists there and has received treatment interventions not only in medication management, but also in what we call cognitive behavioral therapy, a psychotherapy, counseling intervention, and also in eye movement desensitization reprocessing treatment, right? These are specifically designed to treat individuals with PTSD.
And I don't want to use the word despite, but even with those efforts that she has undergone in the last 2.5 years, when you saw her in July, had her symptoms or were her symptoms still persisting as it relates to post-traumatic stress disorder?
Yes, they were still persisting, yes.
And was she still under medication management at that time?
Yes.
And do you recall what medication management she was under at that time?
I don't recall specifically. I do know that she was receiving a antidepressant medication and an anti-anxiety medication. I'm forgetting which one, along with continuing her psychotherapy.
And when does that, I'll ask it this way, your review and what we've talked about so far, does that establish in your mind and in your opinion the duration requirements for post-traumatic stress disorder?
Yes, it does.
And then tell us what clinically significant distress or impairment refers to.
Yes. So the last the last piece there is important, because if a person has all of these symptoms and they don't impact them in their functioning, then it is more difficult for you to say, okay, this is a person who's suffering from a disorder. A disorder requires that there is some impairment of normal functioning. And so the criterion F points to how a person might subjectively experience significant distress to the point that they're having difficulty in their own emotional states day to day. And that might also spill out into very clear, objective loss of functioning in important areas in our life, like work, like socially, family, friends, academically, and such. So we look for an individual to have clinically significant impairment in those areas.
And when we talk about clinically significant impairment, sometimes folks think of being numb to experiences. Have you ever heard that phrase?
Yes.
And can you tell us whether that is something that Ms. Zwerner expressed to you and what significance that has clinically?
Yes. There are times where, associated with PTSD, a person can experience psychological numbness during times when they should really feel something, right? So some folks would think that's counterintuitive, but actually it is a defense mechanism in a sense, where a person's emotional state, where it has been riding high for so long because you feel like you're in danger, in order to try to control to some degree, you have to be able to feel numb as a protective mechanism. Right? So that happens sometimes. Now, this experience causes some confusion for individuals who have it, right? They don't understand why they are feeling nothing right now in a particular situation. And then there are other times where they're feeling too much and they don't want to feel too much. They don't want to feel afraid. They want to be able to go to the grocery store and not to take someone with them. Those sort of things. So it could be very confusing. This is why, psychotherapy becomes important to help folks process this mental health disorder.
And as a clinician, when somebody's reporting, and we've talked about some different topics here, like being disassociated or feeling nothing, how does that appear from a clinician standpoint, and how does that differ potentially from what an average person may expect?
Sure. As a clinician, if I'm sitting with someone who is experiencing that, I'm looking for emotional flattening, right? I'm looking for the lack of expression, a lack of response, a disconnect as I'm speaking with an individual about something that might be, you would expect to elicit some sort of emotional response to, right? You can think of it as a person who has been abused for many, many years, and then they see a violent act, and then they don't even react, right? And the rest of us will say, hey, well, what's going on? We need to move. But that person who has been abused chronically, they don't react in the same way. They don't view violence in the same way. There's a numbing to things, and that's abnormal.
And we've talked about these clinically significant findings or distress and impairment. Where, if anywhere, within the PTSD evaluation does suicidal ideation come into the play, and was that involved in your evaluation of Ms. Zwerner?
Yes, so that would be, yes, there was a point where Ms. Zwerner experienced passive suicidal thoughts. because of the stress that she was feeling on a daily basis. That happened after the January 6th situation, shooting. And she had not experienced that before, passive suicidal thoughts. And at least in the records, there's none of that in there until after. That falls in the criteria under negative alterations in mood and cognition.
And so when we evaluate F, was that met in your evaluation of Ms. Zwerner as well?
Yes.
I want to talk to you on our final sort of stop here about the future.
Yes.
Is there, and we talked a little bit about this in terms of duration and the persistence of her symptoms as of July of this year. Tell us, as we sit here 2.5 years after this incident, what that indicates to you of her evaluation and what that means for her prognosis into the future.
Yes. I am concerned as a clinician because despite significant efforts in terms of treatment, the symptoms persist. As a clinician, I don't know where Ms. Zwerner would be without the treatment that she's receiving now, right? If you understand my point, is that if she was not receiving the treatment that she has received, she would not be in good shape.
And keep going.
One of the very important pieces about Ms. Zwerner's case is that she has everyday reminders, permanent physical scars, reminding her of that particular day. So it's not just that she has psychological scars that she's dealing with from the trauma. She has impairment in her normal functioning, right? She had injury to her hand that has changed the way that she uses her body, that has caused her to have multiple surgeries because she continues to have complications around that. She has physical scars that she sees and she will see into the future when she changes her clothing or something along these lines, right? If she's going to the beach, I would imagine, she might be mindful or thinking about that. And then lasting, she still has a bullet fragment that she knows is in her body, right? That was not there before, right? So that's not going to go away. That's there now. That's something that was not there before. So now these physical, real physical scars and impairment and functioning, they're constant reminders. That's the first thing. The other piece is this, is that she's still having nightmares. So something that's important about nightmares is this. All of us, when we have difficult times with stress, anxiety, depression, some of us will try to escape, right? Escape to, you know what, I need to go to sleep. Hopefully tomorrow will be a better day. I can sleep this off. I don't have to think about it, right? So some of us look to that as sort of a refuge away from emotional stress, emotional difficulties, and such, for some relief there. When a person continues to have nightmares, what that tells me is that that person continues to struggle with such difficulty consciously related to that traumatic event that they can't even escape during sleep, that their unconscious presses into their sleep and then influences their dreams, right? We don't have control of our dreams, you know, when we're sleeping. And so when you have a disturbance of sleep, when you have these distressing nightmares and you wake up and you have this physiological responses, well, then you don't get refuge. And so, I hope that would continue treatment. I hope with, of course, with her, continue, and it sounds like she's been, from what I could see in the records, very active in her treatment and trying to get to a better place. But yes, I'm concerned. I'm concerned about that.
And in your professional opinion, is this post-traumatic stress disorder a chronic condition that will last throughout her lifetime?
Yes. I mean, this is, it's hard for folks to be able to understand who might not have gone through that particular traumatic experience, right? So all of us will be able to understand the loss of a parent, especially if we had a close relationship with our parents, how difficult that might be. But not all of us have had the experience of someone trying to kill us and then surviving that, right? And so it becomes a very unique situation for that individual. It's just a very significant traumatic experience.
It'll be with her as long as the fragment's with her.
Yes.
Doctor, are all the opinions that you've testified to today held within a reasonable degree of medical certainty?
Yes.
Thank you for your time.
Thank you.
Cross-examination?
Hello, Dr. Watson. We meet again.
Yes, good morning.
Good morning. Just to be clear, you've told the jury you were hired by Ms. Werner's lawyers, correct?
That is correct.
And the sole purpose of your evaluation of Ms. Werner is in connection with her claimed damages in this lawsuit.
That's correct.
And you talked about being a clinician, correct?
Yes,
But you are not a clinician to Ms. Werner.
that's correct.
You're not providing mental health treatment to Ms. Werner.
No,
In fact, you don't have an outpatient practice doing, providing mental health treatment to individuals in the community.
no outpatient practice at this point. I have in the past.
Understood. And here, in deriving your opinions, you rely primarily on what Ms. Werner was willing to tell you, correct?
No.
Are you talking about the records that you reviewed?
Yes.
But those would be her self-reports in the records, what
No.
she was willing to tell other providers.
No. So, for example, in the medical records, it shows that she was shot. It shows her physical damages. That wouldn't be her self-report. That she was shot.
Understood,
And-
Dr. Watson.
and-
I'm talking about her narrative about her mental health damages. That would be self-report from Ms. Werner when you met with her, correct?
Oh yes, yes,
And then when you're looking at her records from other providers, it's what her self-report to those providers is.
self-report plus their observations.
And you did not, let me strike that. You told the jury you met with Mrs. Werner twice, right?
Yes,
One was in person.
Yes.
And that was October 14, 2024.
that's correct.
And then you did a Teams conference in July 16, 2024.
That's right.
And that's the total encounters you've had with Ms.
Total of 6 hours. Yes.
6 hours. You did not conduct any collateral interviews, correct?
No,
And
they were not
tell the
necessary.
jury what a collateral interview is.
The collateral information, interviews would be reaching out to family members, gathering additional information from them about history and about current symptoms and current functioning. But it wasn't necessary in this case.
Based on your opinion. Wasn't necessary.
Based on practice, we have I had ample medical records. I have medical records dating back from with our family physicians that track. I mean, as a matter of fact, it was great because I was able to really track through her medical records years and years before this event, all the way up to her symptoms after. And so talking with the family really would have been adding expense that was not necessary in this case.
And you talk about reviewing the primary care records,
Yes.
but you didn't review her counseling records prior to January 8, 2023.
Yeah, no, those were not. It wasn't necessary for me to go backwards because those records that I saw after also referenced her early treatment. So the changes in diagnoses were clear because the clinicians in the at the Abundant Life talked about her previous condition and then talked about her change in diagnoses.
But you did not review the Abundant Life Partners record prior to January 8, 2023.
No,
You did not review.
I did not see
And
those.
there's ample records prior to this event that are in the Abundant Life health records, correct?
Well, I don't know because I haven't seen those, but I saw all of her psychiatric treatment through her family practice well before that. So that would have covered that time period.
You're telling the jury that the primary care records would cover her treatment by her mental health providers?
Yes, because they provided mental health treatment to her through West Point Family Practice. She was receiving all her psychiatric medications through them. She was reporting all of her anxiety. All of that was discussed in there. There was narrative. There was information about her father and what happened with her father. It's all in the West Point Family Practice records.
From the perspective of the West Point family practice providers.
From the perspective of a psychiatrist that does this on a regular basis, all the information that I would need to reach a clinical diagnosis, I had all the information I needed from the clinical providers who were treating a specific symptoms. West Point had all that information. From my standpoint as a clinician and what I need to reach a diagnosis, I had all the information I needed there.
I understand that, Dr. Watson, but you did not review the mental health records from Abundant Life prior to January 8, 2023.
That's correct.
That's correct. You did not conduct any psychological testing?
No, that wasn't necessary.
Okay. And you did not refer Ms. Werner for psychological testing, correct?
Again, not necessary. That's correct.
Did not look at any of her social media reports?
Social media?
Any social media postings or
No
Okay.
social media.
did not interview her coworkers?
It depends on, well, I didn't interview them directly. I had access to depositions.
And you did not observe her functioning in the community?
No, personally, no.
Didn't interview any of her therapists or healthcare providers?
No, not necessary.
Did not interview family or friends who were familiar with her functioning in the community?
No.
Did not review any of her education and training records at the cosmetology school that she attended after the shooting?
I don't believe I had those in the records. I don't recall that.
Did you ever seek verification of her self-report about not using recreational drugs?
That was replete there was plenty of information about that in her medical records throughout. All of it was consistent. Everything that she said to me was consistent in medical records going way back until 2016.
But those were her self-reports.
Right, but there was no testing from any clinician, from the family practice or anything that indicated that she has ever had any substance use problems, that there was any concern, that there was any need to treatment, that there was any urine, drug, or blood tests related to it. That's just not in the records.
I understand that, but I'm asking you, did you seek verification about her self-report about whether she had used recreational drugs?
Seek verification other than the medical records?
Yes.
Do you mean, I don't know what you mean
Did
verification.
you review any text messages?
Whose text messages?
Ms. Werner's text messages.
Text messages about whether or not she uses drugs?
Yes.
No, I didn't.
And you told the jury about Ms. Werner having a dream about a student on the day of shooting other than the student who shot her, correct?
Yes.
Did you ever gather more details about that student to determine whether he was the student who on the day in question told her that JT had a gun?
I'm not following your question.
You talked about the student
Mm-hmm.
who she mentioned dreaming about on the day of the shooting other than JT?
Okay.
And I'm asking you, did you gather any additional details to determine whether he was the student who had told her earlier in the day that JT had a gun?
No.
And you never interviewed her boyfriend even though they lived together?
That's correct.
And he came to your office in Pennsylvania the first time when you met her in person, you didn't interview him?
No. No.
Did you ever review the school security video in the moments immediately after the shooting?
No.
And you never reviewed, again, her, any text messages or social media postings?
That's
Correct.
correct.
And you've not met with Ms. Werner in person since October 15, 2024?
That's correct.
And you've not reviewed any of her counseling records since June 10, 2025, is that correct?
Whatever is there in my report. So I think that was the last set before my last meeting with Ms. Zwerner.
And you addressed the tragic loss of her father, correct?
Yes.
And that was something that you said she had worked through?
Yes.
Okay, and that was, but you didn't review the Abundant Life Partners records prior to January 8, 2023, correct?
Objection asked and answered.
You have any response to that?
I can try to rephrase.
All right,
So
it's sustained.
you did not see in other records where she had been treated for PTSD symptoms related to her father's tragic death?
No, I didn't see anything like
Didn't
that.
see that, because you
No.
didn't review the Abundant Life records.
Objection asked and answered.
Sustained.
And you talk about Ms. Werner being reluctant to be in the public or have a public presence, correct?
That's correct.
But did you review any of her media reports or media interviews that she's giving?
No.
And that would be a public presence. Would you agree? If someone's on the
That she's
Today Show,
appearing in public.
public presence.
So I think that we might, I'm not sure what the circumstances were and what sort of measures were put in place for her to make that appearance.
Did you review the GoFundMe site created by her sister?
No.
And that, putting the story out that way?
No.
That's all I have, Dr. Watson, thank you.
Thank you.
Any redirect?
One clarifying, there was a question earlier from Ms. Douglas about meeting on Teams in July of 2024. That meeting actually took place July 2025.
That's correct. Thank you.
That's all I have, Your Honor. Thank you.
Okay. All right, may he be excused?
You may be.
All right, you are released from your subpoena. Thank you for coming and testifying
Thank
today.
you.
All right, good time to take a short break.
I think so, Your Honor.
All right, and who's gonna be your next witness?
It'll be Ms. Zwerner.
Okay. All right, we'll go ahead and take a 15-minute recess, and then we will call the next witness. All right. All right, court being recessed till 10.
Thank you, Your Honor.
may be seated.
All right. Are you ready to call your next witness? All right. Bring the jury in.
Please stand for the jury. Nine jurors in the box.
You may be seated. All right, ladies and gentlemen of the jury, we had to handle some matters. Those are taken care of, and we are now ready to proceed with the plaintiff's case. Call your next witness.
Abigail Zwerner, Your Honor.
Do you swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Thank you, Your Honor. And Abby, can you tell the jury your name, please?
My name is Abigail Zwerner.
And Abby, how are you feeling right now?
I think nervous is a big one. Nervous, anxious, a lot.
And Abby, the jury's already heard a little bit about yourself from your mother and your sister. So just tell the jury, how long were you a teacher?
About 2.5 years.
And where did you teach at during that 2.5 year period?
Richneck Elementary.
Tell the jury what grades you taught.
I came into 4th grade, my first year of teaching. That was when we had the virtual hybrid year. And then the following 2 years, I taught 1st grade, all at Richneck.
And how did you enjoy teaching?
I liked it. I do remember it was stressful a lot of times. Being a new teacher, a lot of new experiences, a lot of ups and downs I remember. Yeah.
And now, Abby, I'm just going to ask you a few questions about January 6, 2023, okay?
Okay.
So tell the jury, when on that day did you first hear about JT might have a gun?
It was before recess.
And do you remember who told you that?
Amy Kovac.
And when Amy Kovac told you that, why did you not go to Dr. Parker?
I knew that she was going to tell Dr. Parker.
Did Amy tell you she was going to tell Dr. Parker?
Yes, she told me that she was going to tell Dr. Parker.
And did Amy tell you that 2 girls had advised her of the fact that JT might have a firearm?
Yes.
Do you know who the 2 girls were?
I did not.
So she didn't even tell you which kids in the class had told her that?
She did not tell me.
And no other kids told you?
No.
So you heard it from Amy, and Amy said she was going to tell Dr. Parker at that time?
Yes.
Were you told to keep an eye on JT by Amy?
Yes.
And is that why you were texting and communicating with Amy during recess?
Yes.
And Is that why you texted Amy about what you observed JT doing before recess?
Yes, because I knew that once Amy had informed me of the information that the students had told her, I knew that Amy was going to then relay the information to Dr. Parker.
And again, no one else had told you anything about a gun besides Amy.
Correct.
And, Your Honor, I would like to publish and pull back up what's already been submitted as Plaintiff's Exhibit 3, if that's okay with Your Honor.
Which is that?
That is the picture yesterday of Abby wearing a shirt. Oh, 90C? Is it 90C? I'm being corrected that it's Plaintiff's Exhibit 90C, Judge.
Okay. Any objection to that?
No objection to that.
Right, it's already been admitted, correct?
Yes, it's already been
All right,
admitted,
got
Your
it.
Honor.
Yep.
And Abby, do you recognize that photo? It's on the screen in front of you.
Yes.
And what year is that from? Do you know?
I have slightly orange hair. Looks like it's washed out, so it would have been the 2022-2023 school year.
Okay, so you're in your first grade classroom, room 11?
Yes.
And if we can zoom in on the orange sheets that are behind your head, do you see those?
Yes, I do.
Can you tell the jury what is that?
That would be our handbook, our school's handbook. I believe it was titled the Crisis Management Plan. I may be wrong on the title of it, but it was the Tier 1, Tier 2, Tier 3.
So that's the school, that's a handbook that you would reference?
Yes.
And why would you reference that sheet?
For the behaviors, it was like a left and right side.
And why would you look at that, the left and right side?
The like possible displayed behaviors on the left, and then on the right side, actions to take as a teacher.
And Reed, if we can only display to council, please, Exhibit 108, and it would be date stamp 9074 and 9075. Thank you. And Abby, do you see two documents in front of you?
Yes.
Do you recognize those two documents?
Yes.
And what are those two documents in front of you?
The on the left and the right side, it looks like the three. I don't know how to explain it. It's like the combined on the one sheet of paper that I had on the orange sheet of paper, like the level 1 behaviors, and then on the right side of the screen, level 2, and then level 3 behaviors. I had that all on one sheet of paper, the orange paper on the wall.
So the exhibit that we just showed to the jury, the box that you had of the 3 tiers, is from this document?
Yes.
Your Honor, at this time, I would move to submit this document as Plaintiff's 108, and we would mark it as 108.
All right, any objection?
Object, Your Honor. This witness can't authenticate. This is a handbook from Richneck Elementary. She's not an employee. She can't authenticate the document.
Well, she's identified it. That's overruled.
Thank you, Your Honor.
All right, so admitted.
Thank you.
Plaintiff's 108.
May I have permission to publish it to the jury, please?
You may.
Thank you. And Abby, we're now sharing this with the jury, so can you tell them again where this Section 3 came from?
The Richneck Elementary School handbook.
And the chart that the jury is seeing on those 2 pages, is that what was combined into one chart in the photo that we had just previously showed the jury?
Yes.
And can we publish to the jury Exhibit 90C? Is it 90C? Thank you. And if we can zoom in, that orange piece of paper behind your head is what has the chart on it with the Tier 1, Tier 2, and Tier 3 behavior.
Yes.
And then if we can zoom in on the level 3 behaviors on the second part of the screen, please read. And do you see what's on the screen at this time?
Yes. At the top it says level 3 behaviors immediately reported to the school security and or an administrator.
And in the student behaviors, is there a possession of a weapon listed?
Possession of a weapon.
And then next steps, that's for the administrator to do, correct? That was your understanding?
Next steps.
And if we, on this date, Amy Kovac went and reported it to Dr. Parker, correct?
Yes.
Thank you. And we can take that down from the screen now. Thank you, Reed. So Abby, now tell the jury, what did you see right before you were shot that day on January 6, 2023?
The moment went by very fast. I remember Dr. Watson touched on it briefly earlier. The look on the student's face is a large memory that I have. I do remember it was like a very blank look, but it wasn't a blank look at all on his face.
And is that why you lifted your hand? Did you know what was about to happen?
Yes. Yep.
And what is the last thing you remember that day at the school?
The last thing I remember at the school. Obvious, I thought I was dying. I thought I had died. I thought I was either on my way to heaven or in heaven, but then it all got black, and so I then thought I wasn't going there. And then my next memory is I see two coworkers around me, and I process that I'm hurt, and they're putting pressure on where I'm hurt.
And Abby, can you describe for the jury a little bit about how you're still feeling physically and emotionally? And I know that's a big question.
Physically,
Can you describe how it is with your left hand still? The things you can and can't do, even to this day? So Abby, can you tell the jury, when we have lunch together, are you able to open your potato chips, or do I open your potato chips for you?
I asked you, we had, we catered sandwiches in a box, and a small bag of chips and cookies were catered, and I was trying to open the bag of chips on my own multiple times, different ways, trying to hold it different ways. And I eventually asked you to open it. It's the same thing with water bottles. Overall, I would say I do struggle with doing things.
And for example, we heard from your sister yesterday, and she described a change in your relationship with not only her, but friends. Are you able to explain a little bit to the jury about how you feel maybe those relationships have been changed?
The best I can explain it, it's like I still feel connected and close, but it's also that feeling of distance, a little numbness, and it's like I know I trust the person I'm with. You know, I love them, I know them, but there's something that's just different. I can't necessarily put it into words.
And what about, we heard from your mother about the movie Hamilton. You were planning to go to it that day. What happened that changed your mind when you had already purchased the tickets and made those plans?
It was a Saturday. I remember waking up. I woke up and I remembered that there was a scene where two characters had dueled with firearms, and when we had started making the plans to see the movie, when the Saturday was coming up to see the movie, it just never flew through my mind. I had seen Hamilton before, but for some reason when I woke up that day to go see the movie, it just flew right into my head, and just overwhelming sense of, I felt like everything just came over my body. And I remember I called my mom. I don't remember if I was crying on the phone to her. I don't remember if it was afterwards, but I remember crying a lot. And I remember that afterwards, they were asking me what else would I want to do instead that day. So, okay, we can't go to the movies. What do you want to do instead? Where else would you want to go instead? And I remember saying or telling them nowhere. Like, I can't go anywhere. I just want to stay home. I'm not going anywhere today. I can't. And I remember that it was my mom and my sister, so it wasn't just my mom and I planning to go. It was my mom, my sister, and I, all three of us planning to go. And then they proposed to come over to my place, and even that still, I didn't want. Like, no, like, just leave me alone. I don't want to go anywhere. I don't want to see anyone. I don't want to. No. To my mom and my sister.
Well, Abby, I know this has been difficult for you, so that's all the questions I have. I appreciate it, okay? Thank you. But stay there. There may be other questions.
Thank you. All right, cross-examination.
might take a little bit of time. I don't know if you want to go try to get through before lunch.
I'm sorry?
My course might take a little bit of time. Let's get it started.
Yep.
Ms. Werner, I have a few questions so that we can make sure the jury understands the whole picture. You've been working as a teacher for a few years at the time of the incident, is that correct?
Yes.
And you had a number of children in your class with some academic issues?
Yes.
You had some children in your class with behavioral issues, is that correct?
I faintly remember.
And when you were dealing with student misbehavior, you would start by talking with the student, is that correct?
Most likely, yes.
And if you needed help, you would ask for guidance or coworkers or administrators to help, is that correct?
Yes.
You would go to Dr. Parker at times, correct?
At times.
You would email her, true?
Yes.
You'd walk in her office.
Yes.
And if necessary, we'd get the guidance counselor to take the student to Dr. Parker's office.
At times.
And Ms. West was another first grade teacher. She was across the hall from you, correct?
She was.
Lead first grade teacher. Sometimes go over there if you needed to speak with her.
Mhm.
You had a phone in your room,
Yes.
and you could call a parent on the phone in your room,
I don't think I've called a parent during the day.
but you could if you needed to.
Yes. Yes, I had a classroom phone.
And you could call the office.
Yes.
Mr. Coleman, can you please show to the witness and counsel Exhibit 90A? Yes, sorry, Defense 90A.
That is plaintiff's 90A, is that correct?
Yes.
All right.
No. She said defense 98 to me and then plaintiff to you, so I just want the record to be clear.
Oh, Defense 90A.
All right. Is that in evidence?
Not yet.
Okay.
Ms. Werner, I'll give you a minute to look at this document.
Are these from me or someone's messages to me?
Is your phone number 804-424 or 804?
So they're from me.
That's a text from you.
Okay. Yes.
Have you had a chance to look at the?
Yes, I read
page?
them.
Is that a text you sent on October 15, 2021?
If that's what it's dated, yes.
And you sent it to Rosalie List?
Yes.
And Ms. List taught with you at Richneck, correct?
Yes.
Was she another first grade teacher?
Yes.
Your Honor, I'd move to admit Defense Exhibit 90A and publish to the jury.
Any objection?
Your Honor, I would just object. I don't see how it's relevant. This is from October 2021. And it's not regarding JT or the year that this happened or the date of the offense.
Yeah, how is this relevant?
It's relevant. If the court will let me explore with her, we can sidebar and I can tell you, but I don't want to obviously do that before I question her about it.
I need you to state why you believe it's relevant.
The text is a text about evacuating the classroom when she felt that she was in danger, that she had done that before.
That's quite what it says, but you can read it, Your Honor.
I think the bottom one is relevant to that, but the top one isn't. So, I mean, I'll overrule the objection as to the bottom one if we redact the phone numbers and then redact the top text.
Then, Your Honor, just pending whatever ruling we make, can we ensure that this remains published only to the witness because it does have private phone numbers that I don't think need to be
Correct. So if we could just post that as it's highlighted there, I'm okay with that.
Yeah, I was not aware of any court ruling about redacting text messages
Well, phone numbers.
or phone
Yeah,
numbers?
phone numbers from
Okay.
the text need to be, yeah.
We can redact it before it's submitted.
Okay.
Am I allowed to publish it to the jury before?
Yes, if it goes up exactly like that. Okay.
Ms. Werner, do you recall an incident the year prior with a student named Q?
I don't.
Do you recall you had a student in your class named Q who you felt in danger of and you had to evacuate your classroom?
I don't. I remember a student with the name Q, but I don't remember any of this.
Okay. So if you've looked at a text message where you talk about evacuating the classroom because of student Q and feeling in danger the year prior, you would disagree with that?
Yes, but I also know I've never have officially, technically done an evacuation procedure. I don't know what that. I've never performed a school classroom evacuation.
So Ms. Werner, if you see on the text,
Mm-hmm.
had to evacuate my room early for lunch,
Yes.
and that was because of Q, wasn't it?
Yes, I read that.
And you recall, does that refresh your recollection?
I don't recall what happened.
Mr. Coleman, can you publish to the witness and counsel Defense Exhibit 91D? Have you had a chance to review?
Mm?
Is that also a text message from your phone that you sent?
Yes.
And you sent it on December 15, 2022 at 5:22 p.m.?
Mm?
And that
Yes.
was a few weeks before the events that bring us here today. Is that correct?
Yes.
And you sent it to Jen West, Anissa Miller, and Kristen Ayers, correct?
Yes.
And they were other first grade teachers.
Yes, they were.
And in this text, you told them that you were sorry for crying.
Your Honor, I'm objecting at this point. There was pretrial rulings about prior acts pursuant to Rule 404, Your Honor. This isn't relevant as well. If you can look at the text that's on the screen before Your Honor, we would be objecting.
All
all
right,
those
so there are
bases.
two separate texts, so let's just start with the top one. All right, how is that relevant?
It's relevant to credibility of the witness in terms of statements about, the jury's heard evidence that Dr. Parker didn't look at her, so this is probative of that evidence that's in court from this plaintiff's own mouth.
From December 15th of 2022?
A couple weeks before the shooting.
No, I'm gonna sustain that objection. All right, and then you have a separate argument on the bottom one, or is it, I'm sorry, let's start with the objection first. Is that to relevance as well? Or have you even gotten to that second one?
I had not gotten to
Okay.
the section.
Okay, so on the top one, I'm gonna sustain the objection. All right, are you gonna go to the bottom one, or did you just want the top one?
I want the bottom one.
Okay, all right, let me see that. Same objection,
Yes, Your Honor.
and is it the same date? I couldn't see the date.
It's the same date, Your Honor.
All right, thank you.
Again, it's about a completely separate incident.
Your Honor, the jury's heard testimony from Ms. Kovac and others about Dr. Parker not looking at her on January 6th, and Ms. Kovac made comments about Dr. Parker not doing certain things. This is a text message from Ms. Werner discussing feedback from Dr.
I
Parker.
object to all of the text message.
It's directly relevant.
To what?
Credibility of the witness. It's probative of actions taken on the day of, which they've been able to place in evidence.
No, I'm gonna sustain the objection. It's not relevant. This is on December the 15th.
Thank you, Your Honor.
All right.
Ms. Werner, there was an incident with your cell phone on January 4, 2023, correct?
Yes.
And it involved the student JT, correct?
Yes.
And he threw your phone in the classroom?
He slammed my phone to the ground.
And it broke the screen protector.
Yes.
When he did that, you took him by the hand, correct?
Yes.
And you removed him from the classroom.
Yes, I brought him to Miss West's classroom across the hall.
And you asked her to call guidance, correct?
Call for yes.
And Mr. Rawls came?
I asked her to call for help on her walkie-talkie, and Mr. Rawls and Miss Palladini came.
Okay, so Ms. West could call for help on the walkie-talkie?
Yes, she had a walkie-talkie. I did not.
Okay. And Mr. Rawls came?
Yes.
And he removed JT from the classroom?
Yes.
And he was suspended for 1 day for that, correct?
Yes.
And he returned to school on January 6th?
Yes.
His mother brought him into class?
Yes.
And she apologized for what JT did?
Yes, he did as well.
He did as well?
Yes.
And he offered to pay for the screen protector?
Yes. Casual conversation.
You did not notice anything off about JT when he first arrived at school on January 6th?
I did not.
Now, your class went to lunch around 11:15 to 11:45, is that correct?
Yes.
And we've heard about an incident with JT in the lunchroom, and you personally went to Dr. Parker about this incident, correct?
Yes.
And to be clear, when you went to Dr. Parker about this this incident, you did not report to her anything about JT having a weapon?
No.
So you went back to your classroom after you left Dr. Parker's office?
From my memory of that day, yes, but throughout this week I have learned some things.
Do you recall going back to your classroom at some point before recess?
Yes.
And Ms. Kovac was in your classroom?
Yes.
And you learned from Ms. Kovac that 2 of your students said JT had a gun in his backpack?
I don't remember if Miss Kovac told me who. She did not tell me which students. But yes, Miss Kovac did tell me that students told her that the student brought a gun with him to school.
Did you ask Ms. Kovac who the 2 students were who had reported this?
I don't remember if I did or not.
Did you take measures to speak with the 2 students who had reported this?
No, I knew that Miss Kovac spoke to them.
And they were students in your class?
Yes.
And you didn't feel the need to speak to them yourself?
I knew Miss Kovac had spoken to them, and I trusted Mrs. Kovac.
But you don't know what Ms. Kovac said to those students, do you? Or if she said anything to the students?
I trusted Miss Kovac. She has 20, 30 years of teaching experience over my 2.5 years.
So Ms. Kovac stayed in your room for a while, didn't she?
Yes.
About 30 minutes.
Yes.
And she spoke to JT about what the students said, right?
I don't recall specifically.
You were in the classroom when this happened.
I was.
And Ms. Kovac was loudly talking to JT.
I could not hear what she was saying.
Did you, knowing that you'd gotten this information that your student might have a gun, did you go speak with him?
I did not. Miss Kovac was with him.
Ms. Kovac was in your classroom? So you had coverage in your classroom? Because Ms. Kovac was in there and she had 20 to 30 years of experience, right?
Was that a question?
It was a question.
Could you repeat that,
Ms.
please?
Kovac was in your room when you found out that JT might have a weapon. You had coverage in your classroom. Did you go back to Dr. Parker and say, oh, there's been a change? Now there's a report that he might have a weapon.
At that time, no. Ms. Kovac was in my room investigating the situation. She was observing the student, sitting next to the student, and at that time, I'm trusting Ms. Kovac.
Did you remove JT from your classroom as you had done 2 days prior when you took him by the hand and took him out?
No,
Did you remove his backpack from the classroom?
no,
Did you search his backpack?
no,
Did you go back to the security officer in the lunchroom
no,
who had left, I guess, left a little bit after this time? Is that right, about 12 o'clock?
I don't know.
Instead, you proceeded to teach a lesson before recess. Is that right? And Ms. Kovac team taught that lesson with you.
I don't remember.
So Ms. Kovac has stated that she taught a lesson on Pocahontas with you. You don't remember that?
No.
And eventually Ms. Kovac left the room, correct?
Yes.
And did you say, don't leave, please stay?
She left to tell Dr. Parker that there was a potential of a gun on the student.
But you don't know what she said to Dr. Parker, do you, Ms. Werner?
I knew that she left to tell Dr. Parker what the students had told her.
But you don't know what Ms. Kovac told Dr. Parker?
Her specific words, no ma'am, I was not there with
You were
her.
not party to that conversation.
Correct, I was not.
And when she left, did you ask her to stay or to remove him from the room or to remove his backpack from the room?
No.
Now, we've heard that you saw JT go to his backpack at some time before recess. And did you go personally convey this information to Dr. Parker?
I texted Ms. Kovac.
My question is different. Did you seek measures, did you yourself convey this information to Dr. Parker?
No.
So you took your class to the playground, correct?
Yes.
And you were out on the playground with 2 other first grade classes and teachers,
Yes.
Jen West and Kristen Ayers.
Yes.
Ms. West, she's the one with the walkie, right?
Yes.
When you got out there, did you tell Ms. West, get on the walkie, we've got a student who might have a weapon?
I don't remember.
You don't remember?
No, ma'am.
So you shared with Ms. West and Ms. Ayers what you had learned about JT, correct?
Yes.
And you observed him on the playground.
Yes.
And Ms. Kovac came out on the playground at some point, correct?
I don't remember that. I
Don't remember? And you had left the playground before while the other teachers were out there. We talked about that in your deposition. So did you leave the playground to go back in the building to personally provide information to Dr. Parker?
no.
Did you question JT about anything that you had heard?
No.
And at some point, Ms. West left the playground.
Yes, right before we went inside.
And why did she leave the playground?
To my understanding, something with one of her students.
And did she ask you to shepherd her class and your class into the building?
Yes.
And how many students would that be?
Around 40, maybe.
Because Ms. West needed to go deal with another student discipline issue.
Yes.
Did you say to Ms. West, hey, I can't take your class in. I've got my own problems here. I've got an issue with a student who might have a weapon.
No, because at that time I knew that Amy had told administration, Dr. Parker, I honestly didn't think twice. It was my understanding that administration wouldn't think twice as well
Ms. Zwerner.
when alerted about a potential gun in school.
But you could have taken measures yourself at that time, correct?
Yes.
And you don't know what Amy Kovac said to Dr. Parker, do you?
Exact words, I don't.
So you shepherded 40-some students in the building.
Yes.
JT was in the midst of those students, correct?
Yes.
You had the children line up on the wall out of your classrooms?
Yes.
And you went into the class
Yes.
and you did small reading group.
Yes.
You still hadn't removed JT from the classroom?
No.
And you recall that his backpack was next to his chair?
Yes.
Ms. Werner, at some point on January 6th, did a student named R tell you that JT had a gun?
No.
Do you don't recall saying, save it for later, or sit down to that student?
No.
That didn't happen?
No.
And the first time you saw JT with a gun, he was at his desk, is that correct? The
Yes.
first time you saw a gun that day.
Yes.
And when you saw that, you were shocked,
Yes.
because you didn't expect to see that, did you?
It was a real gun. Yes.
Is there a point where you didn't think he might have a real gun?
Well, the whole day I was contemplating it could be real, but it also could not. When you hear the word, he told students he brought a gun with him to school. There is that possibility.
Ms. Werner, you were asked about the staff handbook. Can you pull up, it's, what exhibit is this? Is it
108.
108? 108? Warner 9074. Mr. Coleman, the top paragraph. Mrs. Werner, do you see the third paragraph? Can we publish to the jury? I think it's in evidence.
This is just the cover. That's all we can see.
Yeah, it's 108. Appears to be page 7, I think.
I can see it, yes.
Your Honor, may we publish it to the jury since it's already in evidence?
But this is your version, right? Your copy of it, or
No,
it is the plaintiff's?
it's
Okay,
the
very well.
plaintiff's, Your Honor.
Yes.
Ms. Werner, looking at the third paragraph, it says discipline is the initial responsibility of the teacher. Is that correct?
Yes,
You agree with that?
it says that.
And let's look at the next page. The boxed behaviors. You spoke about that with the jury a while ago. Ms. Werner, student behaviors on the left is possession of a weapon. Do you see that?
Yes.
And the next steps are secure students and ensure safety. Did you do that when you got a report that JT might have a weapon?
I did not.
And the next step is 2, immediate notice to administrator. Did you yourself notify an administrator?
Amy Kovac did.
I'm
I
asking.
did not myself.
Did not yourself. Mr. Warner, the jury's heard a fair amount about your physical damages from your treating doctors the last couple of days. You eventually resigned from the Newport News Public Schools, is that correct? And you worked for a few months at a gym, Burn Boot Camp, is that correct?
Mm-hmm.
And you and your sister Hannah also worked out there pretty frequently, is that right?
Beforehand, yes.
Before
January 6th.
you would disagree you were still working out at Burn Boot Camp after?
Oh, I did go work out afterwards when I had started working there at the front desk in the fall of 2023. My doctor had cleared me to do light work, light exercises. So I tried my best to work out the best that I could with the weights. Best I could.
And the jury has heard testimony about your emotional damages, correct? We heard from Dr. Watson today.
Yes.
You started seeing your therapist at Abundant Life regarding emotional problems back in March 2021. Is that correct?
That sounds right.
And that was about a year and a half prior to January 6th.
Yes.
And you've been taking an antidepressant daily since 2021.
Yes.
And you told your therapist that you've been diagnosed with depression and anxiety for a number of years. Is that correct?
Yes.
You've been treated for generalized anxiety disorder
Yes.
and a major depressive disorder.
Yes.
And Ms. Werner, you felt a lot of stress and burnout from being a teacher. Is that right?
Yes.
And you had also tragically lost your father in June of 2020.
Yes.
And you had worked with Ms. Gonsalves on recovering from PTSD symptoms related to that event, because that's an event you witnessed. Is that correct?
Yes.
Mr. Coleman, can you show the witness only defense exhibit 109 at 83?
Let me read it, okay? All right, I know you all have.
I've read it.
Hold on 1 second. All right, objection is, state your objection for the record, please.
Your Honor, her introduction of this text message is irrelevant.
No, relevance is the objection. Your response?
Clearly it's relevant, Your Honor. She's had multiple witnesses parade in here and say that she has social anxiety and cannot even leave her home. This was produced by Ms. Werner. It's actually an Instagram post, and it's directly relevant to her ability to function in the community following this incident, which she's placed at issue here.
All right, I'm going to overrule the objection. We can also issue a limiting instruction if necessary that it only goes towards the testimony to contradict the symptoms.
Yes, Your Honor, thank you.
All right.
Ms. Werner, is this an Instagram post you made on September 13, 2023?
It's a private message I sent to Taylor Swift.
Move to admit it into evidence and publish to the jury.
Over plaintiff's objections noted.
Would you like me to read it out loud?
No, is it posted on that? I can't see that.
It's posted.
Oh,
Posted.
okay.
They'll read it.
We'll let the jury, have you had a chance to read it, Ms. Werner?
Yes.
Ms. Werner, you just told the jury this is a Instagram post,
It's a private message to
private
Taylor
message.
Swift.
Private message to Taylor Swift, and you gave that message on, or sent that message on September 13, 2023. And you let Ms. Swift know that you were the teacher from Richneck Elementary School who had been shot,
Yes.
and that you had been to the Eras Tour in Philadelphia. And that was in May 2023, correct? That you went to the Eras Tour concert in Philadelphia?
That seems around that time. Yes.
That was a few months after the tragic shooting, correct?
Around summertime of 2023, I remember.
It was
Yes.
a few months after you recovered from your physical injuries. Is that correct?
4 months.
Okay. And you told Ms. Swift that you were involved in a long court case from the shooting and asked her not to post the message.
Yes.
And you state that you're trying to keep your personal life out of the media. Is that correct?
Yes.
Mr. Coleman, can you please show the witness only Defense Exhibit 109 at 82?
Or just have the same number, or?
Yes, it's 109 at 82, and that was 83. So it's a page number. It was produced in discovery by the plaintiff, a series of social media posts and text messages.
All right, so now we're gonna label, so I've admitted that, so that's defendants 109-82, and this is gonna be 109-83.
10983
All right,
is
for
the
identification
Taylor
at
Swift.
this point.
Yes, and
Okay.
10982 is a different.
Your Honor, I think the record's a little confused.
Okay,
The
yeah, let's try that.
83 was the one that we just looked at.
Okay.
82 is what I believe she's.
That's what I just said.
One of us had it switched. Okay. All right, so this, we're gonna, defendant 10982 is what
Correct.
you're showing her now?
Yes.
Okay, thank you very much.
Ms. Werner, I'll give you a minute to read through this document. Is this a private message you sent to the band Odessa?
Yes.
And you sent this message on September 13, 2023 as well.
Yes.
Move to admit Exhibit 109 at 82 into evidence and publish to the jury.
Right, any objection?
I'm not gonna object, Your Honor.
What's that?
I'm not
No,
gonna object.
no
Your Honor.
objection. All right.
And Ms. Werner, in this message, you let, Odessa's a band, correct?
2 producers. Yes.
And you let 2 producers, it's a music show. Is that
Yes.
correct? And you let this band or producers know that you were the teacher from Richneck Elementary School, is that correct?
Yes.
And that you had been to their show in Bristow, Virginia, the night prior.
Yes.
And they're an EDM band, correct?
Yes.
And EDM is an immersive sensory experience where they use strobe lights and visuals during a concert, is that correct?
Yes.
And you told Odessa that you had had so much fun at their show that you were in awe and hoped to go back again.
Yes.
And then you also told Odessa that you were involved in a long court case from the shooting and asked the band not to repost the message
Yes.
because you were trying to keep your personal life out of the media.
Yes.
Ms. Werner, you've given interviews about the events at Richneck on numerous occasions, correct?
Yes.
You've been on the Today Show.
Yes.
You've also, your sister's also created a GoFundMe page.
Yes.
There are T-shirt sales that benefit you. Now, Ms. Werner, you went to cosmetology school, correct? And that was in January 2024, is that right?
Yes.
And this was something that you had considered for years prior to the events of January 6th, is that correct?
Not realistically.
Mr. Coleman, can you please show the defense exhibit 96B to counsel and to Ms. Werner?
I can't see the date on that. Can you bring that up?
Your Honor, I think the context would be helpful to counsel as well, so that we can understand the larger scope of it.
All right. Are you gonna lay some foundation?
Yes.
All
Ms.
right.
Werner, is this a text you sent to Rosalie List? And Rosalie List was a fellow teacher with you, correct?
Yes.
Now, that was on September 11, 2021.
Yes.
And in the text you said, "Ugh, I'm not ready to teach. If I quit, I'd go to cosmetology school." Is that right?
Yes.
That was a couple years before the events that we're here for today.
Yes.
Ms. Werner, Mr. Coleman, can you please pull up Exhibit 96, P1?
96B, Ms. Douglas?
I think it's just 96, Your Honor. Plain 96.
Display 96. Did you want to display this one?
The text message about cosmetology school
Yeah,
has not yet been.
Oh, I'm sorry, I thought it had been,
identified
yeah.
as 96.
We'll go ahead and pull 96B up. I apologize. I thought it was up. So that was a text that you sent to Miss List a few years before.
Yeah, I think I also joked about stripping as well.
Ms. Werner, I didn't include that text. I didn't include that text. Apologies for getting the numbers wrong, but Mr. Coleman, can you please pull up Exhibit 96?
Are we admitting 96B?
Yes, admitting it.
Okay.
And I have no objection, Your Honor.
All right.
Have you had a chance to look at the text?
Yes.
Is this also a text you sent to Ms. List on October 17, 2021?
Yes.
May I move to admit Defense Exhibit 96 and publish to the jury?
Let me see what he's able to bring up there. All right, so that's what you're at. I guess you can't see?
I can't see, no.
Okay, why don't you take a look at that and make sure that's what you want to
Yeah.
publish? All right, any objection to those three parts of that exhibit?
I just want to make sure, Your Honor, when we're getting these snippets up on our screen that are being shown to the jury, that's not the full document that's been disclosed. So as long as whatever Your Honor's ruling on is just what we're seeing on the screen.
Correct.
Okay.
At this time, and then if you
Correct.
need any follow-up or whatever else you want to, I'll let you redirect.
Understood, just wanted to make sure.
Okay, so we can publish this
Yeah.
as shown on my screen.
That's fine.
All right.
Have you had a chance to look at it?
Yes.
And did you find an Aveda school for cosmetology and send it to Miss List?
Yes.
You told her that they had a school in Arlington?
Hmm.
Mr. Coleman, can you please show the witness Exhibit 96J? Ms. Werner, is this a text you sent to Miss List on October 18, 2022?
I'm not sure who I sent it to, but yeah, it's a text I sent.
Okay. It says to Rosalie List, is that correct?
I can't tell from here.
Can you see?
show her that. You can show her
Yes, I did.
Okay.
All right, so remove
And
that.
that's about a year later, correct? the fall before the events that bring us here today.
Yes.
Any objection?
Move to admit it.
Okay. All right. As shown on my screen.
And Ms. Werner, in the text, you told Ms. List that you didn't even know if you wanted to teach anymore, but you didn't want to waste all the money that you had spent going to school. Is that correct?
Yes, I said that.
And you said that you would love to go to cosmetology school.
Yeah.
You went to cosmetology school, correct? About a year after the events that bring us here today.
Yes.
Mr. Coleman, can you please show the witness only and counsel Defense Exhibit 127? Page 3. Ms. Werner, are these your records from Empire Beauty School?
Yes.
Your Honor, may I move to admit and publish to the jury?
Are you just doing one page or both pages?
I think it's going to be several pages of that document.
Okay, so it's one document.
Yes, sir.
All right, any objection to the entire document?
Your Honor, it has her address on it.
Okay.
We can redact that
Yeah,
before it's
we can
submitted to the court.
redact the email, address, and phone number, please.
Ms. Werner, I want to focus your attention to page 4. In the personal background section. Can we publish to the jury, Your Honor?
That meet your,
Your Honor, again, I don't understand the relevancy of all of this, but I don't think it hurts her either.
all right, your responses to relevance.
Ms. Werner has told the jury that she can't use her hand, and she's become a cosmetologist. Clearly, this is relevant.
Okay, I'll allow it, overruled.
Ms. Werner, I'm looking at the personal background section. Question 4. Ms. Werner, in that question you were asked, is there anything that might prevent you from achieving your dream of starting or completing school, meaning cosmetology school, correct?
Yes.
And your response was part-time job at gym.
Yes.
Mr. Coleman, can we move to pages 20 to 22 of the same records? Focus on page 21, and that is physical requirements of the industry. May we publish the heading physical requirement of the industry to the jury?
Any specific objection to that, besides your continuing to relevance?
Judge, I would object to this based on hearsay in the document.
All right, you have a response to that?
It's not offered for the truth of the matter asserted. She certified that she had no issues with these. and that these are
She's
required.
identified the document itself, so I think she's familiar with it. I'm gonna overrule the objection.
Ms. Werner,
If she read, I guess you need to, I will say, you need to lay a little bit more foundation as to this page. She wrote the other pages. This is not her writing, so.
we can jump ahead and then come back. Let's go to page 22, and I think that will take care of the issue.
All right.
Mr. Coleman, can you go to page 22? Ms. Werner, do you see page 22 with your signature on it? Is that your signature?
Yes.
Can we publish that to the jury?
All right, I'll overrule it. That is her signature, and she signed that she understood the agreement. All right.
Go ahead and pull up the signature. Okay. Jury's looking at it now. Ms. Werner, that's your signature on this document, correct?
Yes.
And if you go back to the prior page, it discusses the physical requirements of the industry. On page 21, we'll go back to that.
Yes.
When you signed the document, you acknowledged the physical requirements of the industry of cosmetology. Is that correct?
Yes.
And let's go through them. The first one is arm-hand steadiness, the ability to keep your hand and arm steady while moving your arm or while holding your arm and hand in one position. You not acknowledge that you were able to do that, correct?
Yes, I signed the document.
Second one is manual dexterity, the ability to quickly move your hand together with your arm or your hand to grasp, manipulate, or assemble objects. You signed that as well, correct?
Yes.
Finger dexterity, the ability to make precisely coordinated movements of the fingers of one or both hands to grasp, manipulate, or assemble very small objects. You acknowledge that as well.
Yes.
Trunk strength, the ability to use your abdominal and lower back muscles to support part of the body repeatedly or consciously over time without giving out or fatiguing. You acknowledge that requirement, correct?
Yes.
Multi-limb coordination, the ability to coordinate two or more limbs, for example, 2 arms, 2 legs, or 1 leg and 1 arm, while sitting, standing, or lying down. It does not involve performing the activities while the whole body is in motion. You acknowledge that requirement, correct?
Yes.
You completed the Empire School cosmetology program, correct?
Yes.
And to become licensed, you successfully completed the 1,500-hour education requirement.
Yes.
And you passed all practical examinations prior to earning your license in July 2025. Is that right?
Yes.
And to do this, you had to complete subject matter instruction at the school?
Yes.
And you also had to complete practical performance examinations.
Yes.
This involved hairstyling, hair cutting, and hair coloring.
Yes.
And in fact, you were quite good at school, weren't you, Ms. Werner?
Was I good at school?
You had a 97.4 GPA.
On my tests, yes.
And you have provided photographs of your work as a cosmetologist to salons. Is that correct?
Yes.
Mr. Coleman, can you please pull up Defense Exhibit 112, page 6? Do you recognize this document, Ms. Werner? Move to admit and publish to the jury.
All right, any objection?
No objection, Your Honor.
All right.
I think there are several pages if you want to take your time going through them.
I see these three.
Mr. Coleman can move to the next pages so that you can look at them all and the jury can see them. It's page 7.
No faces in any of them, correct?
I don't believe
No
so.
faces, Your Honor.
Okay.
Are they, Your Honor, they have different stamps?
I was just gonna get to that, yeah. Pages 6, 7, we're now at 8.
Yeah, and we
All right.
we don't have an objection to them, but for the record's purpose, we were shown 6, and now we're looking at 7 and 8, and I just
Correct.
wanna make sure it's clear.
Yeah.
It's all exhibit 112, pages 6, 7, and 8.
That's how they'll be referred to. I guess we don't need to black out those faces, right?
Ms. Werner, have you had a chance to review all of these? And is this a composite of your abilities and work as a cosmetologist? Is that right? And no doctor's ever told you that you cannot work as a cosmetologist?
Correct. I will say, flipping through the photos, can we go back to the first one, please?
Sure. Page 6.
Yes. All of these three right here, I did have assistance pretty much throughout with an educator or at least one classmate.
Understood. But you've put these photographs out to salons in order
One
to
salon.
get one
Yes.
salon in order to get a job.
Yes, one job that I applied for.
Ms. Werner, we heard Dr. Watson testify that the use of recreational substances would change his findings. Do you recall that?
Objection, Your Honor, misstates the testimony.
Can you re-ask ask the question again for me?
Ms. Werner, you heard Dr. Watson discuss whether you had reported a history of using substances. Is that correct?
Objection, that was also not part of the testimony, Your Honor.
Yeah, I don't recall that either, so I'm gonna sustain it on misrepresenting the testimony unless you can prove otherwise.
Ms. Werner, you heard Dr. Watson say that part of his evaluation was to determine whether someone had any experience in their life before what we call the incident event. Is that right?
Could you say that one more time?
Do you recall Dr. Watson, you were sitting here for his testimony, say, when considering someone's history, part of his evaluation was to try and determine whether somebody has had any experience in their life before what we call the incident event. Do you recall that?
Yes.
And do you recall him saying that whether or not that individual has other factors that may be influencing their behavior and their symptoms, for example, is that person using substances? And you reported to Dr. Watson
Your
that...
Honor, it's an incomplete statement of the transcript. It talked about addictive use of substances.
What are you reading from?
The transcript of Dr. Watson.
Okay, I just wanted, obviously I can't see what you're looking at. Did you read it exactly as it's
Yes,
stated?
for example, is that person using substances an addiction? Are those addictions actually more likely to be responsible for the symptoms?
Right, so your question is, did you hear him say that? Overruled any of that, withdraw the objection at that
Now
point?
that it's been read in full, yes,
All right,
Your
very
Honor.
good.
And Ms. Werner, when you reported to Dr. Watson, whether you were using substances prior to the event, you didn't report truthfully to that, did you?
No.
I don't have any further questions, Your Honor.
All right, how long do you plan for redirect?
Short, 10 minutes, Your Honor, 15 minutes. Hopefully that's not more time.
Right.
So Abby, just a couple more questions. I know you've been sitting there for a little bit. First, tell the jurors, are you proud of your work as a cosmetologist thus far, getting that certification?
I am.
How hard was that for you to do?
Really hard. I had a lot of pain. I had a lot of help. But I did it. I did it.
And is that something that's brought you joy in the past, hair and makeup? You've seen your previous text messages. Is that something you enjoyed as a hobby prior to
Yes.
teaching?
Hair, makeup, yes.
Did you ever think you were really going to give up teaching to be a cosmetologist?
No, that's figure of speech. I joked about stripping.
Were you really going to do that?
No.
And tell the jurors, you're not able to get a job right now as a cosmetologist because of your hand, correct?
Yes, but my previous surgery this April, it's still healing. I was wearing a brace until earlier this month, and was just recently being able to take it off earlier this month. So it's still a little bit more, I guess, raw, if you will, still getting warmed up to move again.
And when you were getting certified, did everything take you much longer than everybody else to do the hair? Without help, if you didn't have the help?
I wasn't fast at hair. I remember that. I felt like I took a very slow time completing tasks, completing people's hair.
And after you've done that, how is your right hand, the hand that was not shot?
The past multiple months, I've noticed pain in this area, overuse, and now my wrist as well.
And is that from overuse of your right hand?
That's what I have been told.
And tell the jury, when you got that part-time job at the gym, why did you get that job?
I remember, when I think about that, it just makes me remember I just wanted to feel like a person again. It was a familiar place, the gym my sister and I were a part of. We went to almost every day, not all the time.
Before the shooting?
Yes, before January 6th. So very comfortable with the place, very comfortable with the people there, the workers there. And it came to my attention that they needed an extra person at the front desk just for a little bit of time, early in the mornings.
At that time, were you having a hard time getting out of bed?
Yes, but it was something like I just felt like I needed to be pushed to do that. I had to start feeling like a person again. Try to.
Thank you, Abby. That's all the questions I have.
All right.
Just one follow-up. Ms. Zwerner, you talked about being able to go to burn boot camp before January 6th, but not after. Mr. Coleman, can you please show?
That wasn't her testimony.
Well,
I'm going to ask you to rephrase that.
Ms. Zwerner, you were going to burn boot camp 4 times a week in August 2023. Is that correct?
to work or to work out?
To work out.
I don't know off the top of my head how often it was.
Mr. Coleman, can you please pull up Exhibit 122 P1 so that the witness can familiarize herself with the record? Just publish it to her and counsel.
Which part am I looking at?
Looking at the record to see if you can identify this record.
Yes, it's from my family practitioner.
Okay. And what is the date of the record?
August 2023.
Mr. Coleman, can you go to page 2 of the record, under the heading Depression?
And Your Honor, I am gonna object to this document coming in based on hearsay or authentication.
Yeah,
if
she
tries
hasn't
to
moved
do
it
that.
in yet, right.
But certainly
I think she's just,
her memory.
at this point, you're just asking her whether or not she did or did not say this, correct?
Yes, Your
All
Honor,
right.
I have no intention of moving this into evidence.
Very well.
Just want to ask Ms. Werner about it. Ms. Werner, do you see the heading Depression?
Yes.
And it says 8/5, is that August 5?
Yes.
Went back to gym with sister 4 times a week mostly.
4 times a week, mostly. Yes.
Mostly, by August.
At most, 4 times a week.
No further questions?
All right, you can step down and sit back at council table. All right, I think now's a good time to take a lunch break, and then I'll hear motions. I'll give you a chance to talk. And at that point, over lunch, I would appreciate you making sure there are no other witnesses or any motions that you want to make at that time.
Yes, Your Honor.
That's what we'll start off with, and then I'll hear any motions that are appropriate at that time as well.
Yes, Your Honor.
All right, and then we will see where that goes. Okay. All right, ladies and gentlemen, it is lunchtime. We will take our hour lunch, and you are excused. Please do not talk about this case or anything you've said or heard yet. All right, you may be seated. Believe you want to go on the record, Mr. Bright?
Go on the record, doesn't matter. I just mentioned to council the fact that we're going to be resting in an hour, maybe short for them, and we'll be sitting back there. If you wanted to give them more time, it may be the best time to give them a longer lunch instead of getting stuck in. The sun finally came out after.
All right, well, we will check on them at my plan. No, I'm not going to take you up on that. 1:45. I want to get 12. I'm sorry. 1:45. I want to get going again.
Yes,
Okay?
Your Honor.
All right. Court is in recess to 1:45.
Please rise. may be seated.
All right, good afternoon. All right, kind of want to go over, I guess, the plan for the afternoon. It's still your intention to rest?
Yes, Your Honor. We have just the exhibits ready to be tendered to the clerk that have been already moved and admitted by Your Honor during the pendency of our case. They've all got the stamps and stuff on them now.
All right.
Once we do that, we're resting.
Okay. Is the defense calling any witnesses after motions?
Yes, Your Honor. In the event that there was an adverse ruling, I would intend to call Deputy Blythe as the sole defense witness for today. And then I would ask for additional time after that to confer with counsel about any additional witnesses that we may call, depending on how evidence shakes out and how this motion proceeds.
Okay. All right. So what I've done before is I've let the plaintiff rest outside the presence of the jury. We've done the motion so the jury's not up and down, and then I will let you officially rest in front of the jury, and then I'll ask you to call your first witness. Does that make sense to everybody?
Yes, Your Honor.
Okay. All right, you have yes, Ms.
There's a
Bright?
motion about the first witness before we get to that witness.
All right, but after you rest.
Yes, yeah.
Okay, right, okay.
Just schedule it.
All right, very well. All right, you have exhibits you'd like to tender?
Yes, Your Honor, I have, and I'll just go through them in Ms. Douglas's presence. We have 3A, 3C, 3E, 3F. Those were all during the testimony of Corporal Blythe. Then we have 90A, 90B, which were admitted during the testimony of Miss Julie Zwerner. And we have 90C, which was admitted during the testimony of Hannah Zwerner. And we have 108, which was admitted, the sections of 108 that were admitted during the testimony of Abigail Zwerner. And then on a flash drive, Your Honor, we have Exhibit 4, 110A, 110B, 9A, and 90D.
Okay. Madam Clerk, does that match up? All right, very well.
And
Any
20
objection besides everything already noted?
No
Okay.
objections preserved on, as argued.
Correct.
And 22 was previously admitted and provided to the clerk.
Okay. All right, with admission to those objections preserved, do you have a motion?
Yes, Your Honor, we rest now.
All right.
We do wish, and it's to Your Honor's preference, we wish to raise that motion for reconsideration on Your Honor's ruling as it relates to the existence of a special relationship duty owed by defendant Ebony Parker to Miss Abigail Zwerner as part of a class of individuals, if we may be heard on that at this time.
All right, I mean, is it anything outside the briefs that you've already filed? Or it is?
It is, Your Honor.
All right. All right, so you have rested, or no, do you want to make that motion before you rest, I guess?
Yes.
All right. All right, go ahead.
Judge, I say the defense would object to this argument being heard, just because I think I would rest on the prior arguments that I raised for the defense of the motion and limit to limit their theory of prosecution. There are some overlapping arguments here. I would just contend that this is not an appropriate time to attempt to revive a prior theory, alternative legal theory. This court has already heard it and considered a motion for summary judgment and dismissed with prejudice.
All right, I'll hear the objection at this time.
Yes, Your
Or
Honor.
the-
Your
I'm
Honor.
sorry, the motion at this time.
Your Honor, ultimately, when a claim is pled as a duty for the special relationship was pled in this action, which was count 3, it remains before the court, and it is the province of the court to reconsider or reevaluate its rulings at any point in time before the case is dismissed. And specifically, the courts have observed in circumstances involving motions for reconsideration, if there's been a ruling as it relates to a motion for summary judgment, which is a mixed question of law and fact. In other words, facts were provided to the court at that time, which may not have been wholesome or complete as it relates to what has now been preserved or presented at trial. It is appropriate to renew the motion, and then ultimately Your Honor will rule on it as Your Honor deems appropriate and fit. So the legal position here, Judge, is grounded in the court's decision, the Virginia Supreme Court's decision in Burns v. Gagnon, which was, as we've cited before, 283 Virginia 657. And specifically, it is a special relationship that was first recognized by the Virginia Supreme Court in the Burdett case. The Burdett case involved a case involving a sheriff's deputy who came across an individual on the side of the road. And the observation of the court in that case, and this is a quote from the Burns case, which is quoting the Burdett case, which says, "When a negligence claim is made against a public official, a distinction must be drawn between the official's public duty owed to the citizenry at large and the official's special duty owed to a specific identifiable person or class of persons." And then the court goes on to say in Burns, not quoting Burdett, "Only a violation of the latter will give rise to liability," quoting Burdett again, "because it is not in society's best interest to subject public officials to potential liability for every action undertaken." It goes on to say that in determining whether a special relationship exists under the present facts, that is the facts in Burns, it observed that here it is important to consider whether Burns reasonably could have foreseen that he would be expected to take affirmative action to protect, in that case, Gagnon from harm. What we have here, Your Honor, is a duty that reflects exactly that, in our view, which is that the assistant principal, based upon the documentation that's been submitted, that's Exhibit 22, Exhibit 109, the testimony of Farish and the testimony of our expert, as well as the others, who all were under the understanding of a protocol that the assistant principal had a special relationship as it relates to each of them to handle circumstances, specifically as it relates to the possession of a firearm, but certainly when there's a foreseeable risk of a firearm on campus. And under those circumstances, the court has recognized that while Ebony Parker did not owe a duty to the public or the citizenry at large, there was an identifiable class of persons at Richneck Elementary School who were under or subject to reasonably foreseeable harm, to which she did owe a duty. That is a special relationship separate and apart from the assumed duty of care that we've talked about previously. And as a result of that relationship, Your Honor, we believe that the evidence sufficiently demonstrated, A, that it existed, that is, there is a distinct special relationship between her and individuals, which Ms. Zwerner is a class member of, as a teacher, as a staff member of that school at the time, and then also that there was reasonable foreseeability in this circumstance in light of the fact that there were repeated multiple reports that reached Miss Ebony Parker, Dr. Ebony Parker, excuse me, as it relates to the firearm on campus and in the possession of JT. And I bring that point out because one of the foreseeability analysis in this case and other cases is, do we know who might have something that's dangerous? And it was Nina Farish's testimony that specifically quoted Dr. Parker in terms of her interview that identified it. A, Dr. Parker was aware of the gun. B, Dr. Parker was aware that JT was reported to have the gun. And C, through the testimony of both Nina Farish and Mr. Rawls, as late as 1:40 p.m. that afternoon, 2 hours roughly after her first notification of a firearm, there was still understanding that there was a firearm present on the campus in light of the fact that they said, let's wait and see once mom gets here. It wasn't, we don't need to, there's no firearm. It was, let's wait and see. And so in light of those circumstances, Your Honor, we believe that it is appropriate to instruct the jury when we get to that point as it relates to a special relationship first recognized in Burdett, affirmed in Burns, and then demonstrated through the evidence today.
Thank you. The court's going to deny your motion to reconsider and relies on its opinion previously published in this case on that issue. All right. Now, having made that decision, any other motions?
Yes, there's a motion from the defense judge. Motion to strike.
Oh, now you're resting, right?
Yes, Judge.
Okay. Plaintiff now rests. All right. Mr. Hogan.
May it please the court.
You may proceed.
Your Honor, for convenience, I've shared some case law with opposing counsel. I'm sure he's familiar with it. If I may pass this up to the court as well.
All right.
I'm sure Your Honor is very well familiar with this. We have litigated this many times, these issues, but I think it will still benefit the court. Thank you. And Your Honor, let me note as a threshold matter, there will be two components to this motion. The first, I intend to proceed on an ordinary motion to strike based on the elements and whether or not the plaintiff has established a prima facie showing necessary to survive a motion to strike. In addition, after this, my colleague, Mr. Alex Bennett, will approach the podium and make a renewed motion to dismiss based on workers' compensation. I'd ask the court to consider that as well.
I'm not
But
going to hear argument on that.
I understand, Judge.
You can renew it now. No, that you need another associate to do it. But That'll be a real quick decision.
I understand, Judge.
All
Just
right.
want to make the court aware of that.
All right.
With respect to the motion to strike, Judge, the standard's well established, even viewing the purpose of the motion to strike. It is proper to grant one where it is conclusively apparent that the plaintiff has proven no cause of action. The court has to require and accept as true all the evidence favorable to the plaintiff and grant the plaintiff any reasonable inferences that may be drawn from the evidence. This is a very favorable standard. We can view the evidence in the light most favorable to my opponent. Nevertheless, Judge, given the binding and unequivocally clear Virginia case law when it comes to the assumption of a duty in the specific context of third-party intentional or criminal harm, the steep threshold evidentiary showing that is required to trigger that obligation, combined with the steep evidentiary showing that is required to establish gross negligence, I would contend that they have failed to make a prima facie showing. To give a quick overview, in this case, plaintiff needs to establish that, number one, Dr. Parker voluntarily and expressly assumed a duty to exercise reasonable care to protect Abigail Zwerner from third-party criminal harm. I understand my opponent will dispute that this is criminal harm. The same doctrine under the assumed duty applies equally to intentional harm, so it is immaterial. For purposes of this hearing, I'll just reference it to as third-party harm. That's number one. Number two, they need to establish that Dr. Parker breached that duty under the relevant standard of care to a degree amounting to gross negligence. In addition, they need to establish that that gross negligence was proximate cause of the alleged injuries. And then, in addition, they need to establish the three potential prongs under the restatement second of torts, as recognized in Burns versus Gannon. And under Section 324A, there are three potential avenues for liability there. In conjunction with the elements I've just identified, they need to establish either that Dr. Parker, her gross negligence increased the risk of harm to Ms. Warner, or Dr. Parker undertook to perform a duty owed by another person to the plaintiff, or yet alternatively, number three, that Ms. Warner suffered harm because of her or a third person's reliance upon Dr. Ebony Parker's alleged undertaking. And I'll talk about reliance and emphasize it in the course of this argument, Judge, because case law has shed light on what is required to establish reliance. So focusing first, Judge, on the duty element. First and foremost, two pieces to this, Judge. It's got to be express, and then number two, there's authority establishing that a promise alone is insufficient as a matter of law. It needs to be combined with an affirmative act in furtherance of actual performance of the undertaking. Regarding the first point, Judge, the Supreme Court of Virginia has held unequivocally that an assumed duty to protect another from third-party harm cannot arise unless there is an express undertaking. An express undertaking, that means an express communication of a, quote, specifically described undertaking to take on a legal duty to exercise reasonable care to protect another from third-party harm. It has to be clear, unambiguous. It has to be talking, saying something. The case law is established that an implied undertaking is insufficient. And the case law has also established, it has defined an undertaking. In general, it is referred to, it equates to a promise or agreement. So what this means is that in the context of third-party criminal harm, in order to be on the hook for that, they need to establish that there is an express communication of a specifically described undertaking that's essentially a promise or agreement that Dr. Parker said to the plaintiff or to another person in the course of the day on January 6, 2023. A promise or agreement specifically to protect the plaintiff from the criminal harm or intentional harm that befell her. And the record is devoid of that, Judge. We've heard no testimony whatsoever that Dr. Parker made any express promise to anyone. At most, it has always been a reliance on implicit or implied tacit assurances. In fact, that was expressly pleaded in the plaintiff's complaint. In paragraphs 41 and 42 of the complaint, they alleged specifically that Dr. Parker, quote, expressly assumed a duty to protect Abby Zwerner by making certain assurances that were, in essence, assurances that JT was unarmed, and then failed to fulfill those assurances by taking additional steps to ensure that they were true. That was their allegation. But we haven't heard anything about any express promise or agreement to say, I am going to protect you, Abby Zwerner. At most, it has been implied. And there's good reason for these principles, Judge. The reason is because, in general, third-party criminal harm, those acts are unforeseeable. Generally, as a matter of law, they are unforeseeable because you cannot control the volition of other individual actors. That is all the more so in this case, Judge, where you've heard evidence from the plaintiff's own witnesses repeatedly acknowledging that no one would have expected a 6-year-old to bring a firearm from their home into an elementary school and shoot a teacher. This is as unforeseeable as it gets, Judge. And the rationale for why these rules exist, for the express undertaking requirement, are particularly acute in this case. It has got to be express. It cannot be left to conjecture or implication. It has got to be verbal from Dr. Parker, and that is not here in this case. There's no evidence whatsoever of that. The court has repeatedly reinforced this principle. First, it was articulated in Terry versus Irish Fleet, which the court is familiar with. There's a copy for the court's reference. But that's when they first came out, and the Supreme Court was at a fork in the road. They had to decide, look, we understand that for ordinary negligence cases, you can raise your hand and take on a legal duty that doesn't otherwise exist under the law through your conduct alone, through your voluntary conduct. And they gave examples. They cited the Nold case and the Pullman case. These are all cases dealing with a motorist who's traveling down the road. They see a pedestrian on the sidewalk. They signal over. They have no obligation under the law to signal to the pedestrian that it is safe to proceed. Yet by doing that, they have assumed a duty, or arguably have assumed a duty, to exercise this duty safely. You can't wave someone across the street without exercising reasonable care. And in Nold, they said, yes, that can happen. And whether or not that you have undertaken a duty to protect someone based on those gestures or implied conduct depends on objective reasonableness. But in Terry, the question was whether or not does that same general principle extend to the third-party harm context, third-party criminal harm, third-party intentional harm context. And there they said unequivocally, no. The Supreme Court put its foot down and drew the line there. And the reason they said that, they provided a rationale. It was not arbitrary. They said that if we did not require an express undertaking, to leave this to implication would be too ambiguous. It doesn't define the scope of the responsibility. It doesn't define how long someone undertakes this duty. It's too ill-defined for someone to be subject to liability for these unforeseeable third-party acts. And that's what's happening in this case, Judge. You've heard from their own witnesses. No one could have foreseen that the 6-year-old child would have come to school and brought this weapon and perpetrated this act. It is unprecedented. I acknowledge, Judge, that in the case law under AH versus Church of God in Christ, there is language. Church of God in Christ came in 2019 after Terry, 1 year after Terry, and it acknowledged Terry's holding, but it said, look, conduct that is tantamount to an express communication of a specifically described undertaking may be sufficient to trigger an assumed duty to protect another from third-party harm. And they cited specifically to the portion of the Terry cases cited the Nold cases. I would emphasize, Judge, that did not alter the standard. Terry is the standard. Terry has always been the law. It is the precedent, and it was unequivocal that an express undertaking is required. An express promise or agreement. Implied conduct alone is insufficient. And the Court of Appeals has repeatedly affirmed that principle, recently in Good versus Huguenot Springs. That was 2024 VA App Lexus 441. That is a 2024 case, Judge. And that one, they said, noting that under Terry, a duty to protect another person from third-party criminal harm can, quote, arise only after an express undertaking, meaning an, quote, express promise. It has to be explicit. And when they applied it to the facts of that case, it's very similar. It's informative to what happened here. In that case, there was a landowner who owned property. He allowed and authorized someone to come onto the land for recreational purposes. He did not inform that party that there are tenants that occupy the premises and might become upset. Nevertheless, his guests went onto the property, and unbeknownst to him, the tenants came out. Of course, they became upset, and an assault occurred. He turns around and sues the landowners. He argued that by authorizing them to enter the land, he tacitly assured, without saying it, he tacitly assured that it was safe to do so. And the Court of Appeals rejected that. They said, Terry is the law. You cannot have tacit assurances when it comes to third-party criminal or intentional conduct. It has got to be express. It has got to be explicit. And that's as recent as 2024, Judge. This is binding established precedent. Independent of that, Judge, there's another problem with the duty element, and that has to do with the fact that under Kellerman versus McDonough, which I did not provide that in the materials here, Judge, but we have, I'm sure the court is familiar with it. It appears on our briefs. In the concurrence by Justice Kinzer, he notes that how they use the term undertaking under Virginia law is somewhat ambiguous. Some hold that it's a promise or agreement. Some say that it requires an affirmative act in furtherance. Some jurisdictions apply an amalgam. Here he was emphasizing that, look, an express promise or agreement alone is insufficient. Even if someone promises another that I'm going to protect you, you cannot be liable in tort for that. And part of that has to do with the fact that in Virginia it is well established that nonfeasance, basically liability for not acting, does not impose tort liability. You cannot be on the hook for tort liability generally based on contract. Contract and tort, church and state, generally separate and independent. And that's what happens when all you have is a promise or agreement to do something and there's no follow-through or performance. Then that you're seeking to impose tort liability for what amounts to basically a contract. And in Kellerman, they noted that even though the assumed duty doctrine seeks to kind of reconcile these principles, at the end of the day, what is required to trigger tort liability, there must be an affirmative act in furtherance of the promise. And that's why in Kellerman, that was the case where there were parents who dropped off children at another parent's house, asked them, it's fine if they do a sleepover, but do not take my daughter on a trip. Do not allow my daughter to be driven by inexperienced male drivers. And they promised. In response, in that case, they replied, I promise we'll take care of her, or words to that effect. That is the language that appears in the opinion. And in addition, the mom not only promised that, but she then allowed the children to go to a mall and be transported by an inexperienced male driver, which resulted in tragedy. There was a collision. There was a combination not only of a promise or agreement, but an affirmative act in furtherance, because the mother actually assisted in transporting the children, authorizing their transport by the individual that was prohibited by the other parents. And in Kellerman, they said, look, this is the law. You need an affirmative act in furtherance, not a bare promise alone. How does that relate to this case, Judge? In our case, the plaintiffs have repeatedly asserted, and their witnesses have claimed, that Dr. Parker was indifferent. They argue that people were banging on the door saying, there's a firearm here, and she's not acting. And several witnesses have testified that she did not look up or respond at all. If that is their evidence, there cannot be an express undertaking to protect Abby Zwerner. There cannot be. The absence of action is the complete opposite of what this doctrine is all about. It's about making promises and then failing to fulfill them, or making promises, acting on them, and then ceasing your voluntary undertaking that results in harm. And we have none of those things here, Judge. At best, the critical moments, you've heard counsel in opening statement and during the evidence in this case emphasize that there are repeated reports, 4 reports. Those are the critical moments where the jury needs to consider the evidence and see what evidence was exchanged at that time. And what we've heard is that there's no one who's come into court and said, Dr. Parker has responded, yes, I'm going to get right on that. Yes, I will take care of this. It is all implied. It is all left to their subjective interpretations of her demeanor. You've heard Amy Kovac testify that she went into the office, and Dr. Parker didn't respond when she was talking about searching the backpack. You've heard Abigail Zwerner testify that when she entered the office, Dr. Parker didn't look up. That is their contention. And if that's the case, there cannot be an expressly assumed undertaking to protect another from third-party harm. Additionally, Judge, I want to focus on, under the restatement, we have these prongs. There are 3 prongs for avenues for recovery here. There's reliance, there's increasing the risk of harm, and there's also assuming a duty owned by another to the plaintiff. I'll just be very quick on this, Judge. The theory dealing with liability based on assuming a duty that another person owed Abigail Zwerner, that is not an apposite in this case. It has nothing to do and has no application here. Generally, that type of, that doctrine applies where there's a company that by contract has agreed to render a service for another entity. So it's usually like a security service that by contract agrees, I'm going to carry out this business's safety obligations. We've got none of that here. It has no bearing here. The other component here is increasing the risk of harm. They would have to establish that in addition to an express undertaking, by promising to protect someone, it actually left Abigail Zwerner worse off. It exacerbated the risk of harm. And we don't have that in this case, Judge, because again, their evidence was that Dr. Parker did not act. Not acting cannot amount to an express undertaking. Not acting is their theory, and if that's their evidence, it's insufficient as a matter of law. Finally, Judge, when it comes to reliance, the restatement itself just uses the term reliance, but the case law interpreting it, AH versus Church of God in Christ, and several others, Terry versus Irish Fleet, it's actually 2 components, at least. It has to be justifiable and detrimental. Detrimental reliance requires that by promising or agreeing to protect Abigail Zwerner, it induced her to rely on that and forego taking additional safety precautions she otherwise would have done. The record is silent on that, Judge. We've heard no evidence from Abigail Zwerner, despite the opportunity to testify to this. She never testified that if Dr. Parker had done X, Y, or Z, I would have done this, I would have exercised reasonable measures for my own safety. We have no inducement, we have no detrimental reliance. In addition, Judge, independent of the detrimental element, it has got to be justifiable. Justifiable meaning reliance fails as a matter of law if it's not reasonable. It has to be objectively reasonable. And that's where those motorist cases come in. The Nold case, the Ring versus Pole case, those are all about, look, if somebody knows the true facts, if somebody knows there's a threat and reports it up to somebody, and the administrator or executive says, look, you're safe, there's no need to be alarmed, but you have independently, through your own investigation, with your own eyes, seen there is an imminent threat. If that's what your theory is, that's what your evidence, it would be unreasonable as a matter of law to rely on that. There can be no reliance as a matter of law. This is well established in a variety of contexts, Virginia law, Judge. It's in fraud, it's in the assumed duty context, it appears in judicial estoppel. This is a well-established principle. It must be objectively reasonable. And especially where the party that's asserting reliance investigated the facts themselves and tried to identify what's going on here, what is the threat, they can't rely on somebody else. And that is what happened in the Nold case, Judge. Well, let me say this. That is what happened in the Nold case where there was a pedestrian who they could see, they were crossing the street and they looked and they could see that the driver or motorist to determine and accessible to the pedestrian versus the driver themselves was not in a position to see if there was a threat. And the pedestrian could see. It would be unreasonable as a matter of law to rely on somebody waving you across the street when you can see there's a truck coming down the highway. That's what it means. And so here, taking their evidence, viewed in the light most favorable to them. We dispute this, but under that standard, if they're saying there's a fire, there's a fire, there's a fire, they're watching the fire happen, there's a train crash coming, and then they're reporting to a party who's not present, who's not on scene and witnessing this firsthand. They can't then say, oh, well, we relied on this person who wasn't present. We know the true facts. We know what's going on, but we're reporting to this person who's off scene, and I'm going to rely on what they're telling me that we're safe. That would be unreasonable as a matter of law. Finally, Judge, I just want to emphasize that independent of all of these arguments, at the end of the day, this is a gross negligence case. That is a demanding legal standard, and what it amounts to is they need to establish indifference, not inadequacy. The case law is well established that if the evidence shows that there was an exercise of at least some degree of care by Dr. Parker, this doesn't go to a jury. And this is crucial, Judge. We have heard from Amy Kovac testified, and on day 2 of trial, she, in essence, testified that Dr. Parker assented to a search of the backpack, that Dr. Parker directed her to search the backpack. She would dispute that, but in the transcript, it appears on page 199 of the day 2 trial transcript, she was asked, and so then, Ms. Kovac, did Dr. Parker respond to you or give you any direction? And she responded, she kind of nodded and acknowledged that that's what I was going to do. And Ms. Toscano asked her, you let her know that I'm going to check the backpack? And she said, yes, and she nodded her head. That is a subordinate going to an administrator, telling them, I'm planning to search a backpack, and looking to them for guidance, for direction, was the question. And in response, Dr. Parker nodded her head. What does that mean? That means that is not indifference. That is not someone disregarding reported threats. That is acknowledging the threat, looking to her subordinate, who is requesting assent and authorization to search a backpack, and she's giving it. That is an exercise of at least some degree of care. And just because there was a bad outcome, or some jurors might disagree with the decision that additional steps might have been required, that demonstrates that there was an exercise of at least some degree of care. And it's not just that. There's the searching of the backpack, and there's also the directing other staff to tell Mrs. Zwerner, you can call the mom. You can call JT's mom. If you are uncomfortable, I'm trusting your judgment and discretion. You are someone who is on scene in a position to see whether or not this threat is imminent or not, and I'm authorizing you to act.
So if you agree that that's what the evidence is, aren't those express undertakings as well and undermining your first argument?
I would actually argue two things, Judge. I think these are all, we can argue in the alternative, and they can't have it both ways.
Okay. All right, go ahead.
So I think that's astute of you to pick up on that, Judge, and I think it makes sense. I think their evidence establishes the exercise of at least some degree of care, and alternatively, they fail to establish the assumption of a duty. Thank you.
All right, thank you. All right, I mean, you can stand up and renew your motion on the workers' comp. I'm denying it based on what I ruled on before, so if you want to put that on the record, that's fine. I'm not listening to any argument.
Your Honor, we would just place on the record our continuing objection to the court's subject matter jurisdiction to even hear this claim based on the workers' compensation bar, Virginia Code 65.2-307.
All right, court notes your renewed objection to my previous ruling that this was a personal injury and not workers' comp. All right, I don't need you to respond to that. You can rely on everything we've already said in my written opinion. Okay.
The comp stuff.
Yeah.
Want to respond to the other stuff?
Yeah, absolutely.
Yes, Your Honor. Your Honor, I just observe for the record that I think the understanding of what is well established in the law in Virginia is in high dispute here. And in fact, at one point in time, opposing counsel told you that there is binding authority from the Court of Appeals from, I think it was the Good case, and I think cited another Court of Appeals case, both of which are unpublished, which means that you actually doesn't bind you. And so I think it's important for us to recognize that all of the rhetoric surrounding the argument about what is and what is not the law is not what guides this court, of course. It is what the law says it is. And when we talk about an instance such as this one, and the framing of it from the defendant's perspective, which is that this is an act of third-party crime, or the pivot that we hear today, intentional act, the law says it cannot be. It cannot be either of those things, no matter the evidence before the court. And it cannot be those things because a 6-year-old does not have the capacity for an intentional act or a criminal act. And that's been recognized in the criminal court decisions. We've cited to this in a footnote in one of our motions in limine oppositions. And in fact, it's reflected, at least implicitly, within the Virginia model jury instructions, which talk about the fact that anyone under the age of 7 doesn't even have the capacity to be negligent, let alone gather the mens rea, if we use the criminal term, to actually form any form of intent that is recognizable under the law. And it's important to distinguish that because Terry versus Irish Fleet and the progeny of cases in which they are now citing all stem from this presumption and assumption that it is an intentional crime committed by an adult. We're talking about sexual abuse crimes or crimes of criminal assaultive behavior, all from an adult, never a minor in those cases. And how we can distinguish that is in the Burns case, when it doesn't involve an adult, there is no discussion of that area of the law in regards to this express undertaking. It was before Terry versus Irish Fleet, but in terms of these criminal assaultive behavior contexts. I say that because it's indicative of the applicable law here, which we believe it allows an implied undertaking under 324A, although we don't think that our evidence requires an implied undertaking in order for this to survive a motion to strike and ultimately go to the jury for a decision, and largely for the observation that Your Honor just made right before the close of their argument, which is to say that during the course of this day, and I will hold their feet to the fire on this, if their position is that by nodding her head, Miss Dr. Ebony Parker acknowledged a threat, and acknowledged a threat such that there was a joint action taken by Miss Kovac as her subordinate, that is an undertaking. That is an undertaking specific to a firearm on the campus at Richneck Elementary, beginning at 11:40 in the morning and ending at some point that afternoon when the school is out, when school's out. And why I make that point is that if we were to even look at Terry versus Irish Fleet, the citation that was read to the court as it relates to that implicit or implied criminal undertaking talks about how in that circumstance, the alleged undertaking, this is a quote, is necessarily ambiguous and there is no designated beginning or end to the undertaking. That's not true here. There is a specific undertaking. There is a gun on campus. There is a specific time frame. It is 11:40 and this child's going to leave school at 2:30. That's when mom's coming. And repeatedly from that moment, the evidence has demonstrated that she acknowledged the threat, counsel's words, that they repeatedly failed to act, which is a choice, not nonfeasance, it's misfeasance. And why is it misfeasance? Because the protocols and the policies that have been admitted into evidence said that this is actually what you're supposed to do. You are supposed to do these things in this circumstance. And it is misfeasance not to comply with those protocols. It's not a nonfeasance circumstance. And ultimately, when we get to this issue of is this surviving a motion to strike, which is our narrow issue before the court at this moment, I would point the court to the footnote in the Terry versus Irish Fleet case, which observed that when the issue is not whether the law recognizes a duty, but rather when the defendant by his conduct, in this circumstance, her conduct, assumed a duty, the existence of that duty is a question for the fact finder. And even the Burns case observed that it was inappropriate to make a decision on that case involving an assumed duty of care before it was actually provided to the fact finder to then make a finding as it relates to an assumed duty, and then render a verdict or a decision as it relates to that finding as well. And so on the issues of an assumed duty of care, when we look at the Burns case, which cites to 324A, we believe that all three of the prongs are applicable in this circumstance. A, her failure to exercise reasonable care increases the risk of such harm. Everyone in this school was waiting on the cavalry, and the cavalry was Dr. Parker, because that's what the protocols stapled to the back of Ms. Zwerner's classroom told her would happen. And that's what she understood based on the questioning of Ms. Zwerner, even in cross-examination, was going to happen. And then this argument, as Mr. Hogan points out, which is, well, there's no, it's inapplicable to talk about an undertaken duty to perform a duty by the other to the third person. My question to the court then is, why are we talking about all the things that the other teachers were supposed to do then? If you want to talk about all the things that the other teachers were supposed to do, they've practically demonstrated the assumed duty of care in that regard. And then third, the harm is suffered because of reliance of the other or the third person upon the undertaking. I'd point out to the court, this is where, there's a difference between how you cook your steak, well or rare, and they say it's well-established law, and I'd say their arguments are rare. And the reason I say that is they're citing to cases that are inapplicable in this context as it relates to reliance. When you're talking about fraud claims, or in the context of a case involving a pedestrian on the corner of a road and whether or not to cross the roadway in the Knoll case. It's not about reliance. It's about a question of contributory negligence in the context of crossing a roadway. And the motion that's being made in this moment is not a motion that they've met their burden on contributory negligence. The motion is that we haven't put enough evidence before the court for a reasonable fact finder with all inferences in our favor, in viewing the light of the evidence in our favor, could not reasonably conclude that the issues in the case at bar fall in our favor. And so, as it relates to the duty, I think it's well established, quote from them, and I'll move to this issue of gross negligence. On the point of gross negligence, Your Honor, and just because I think that this is an issue that will obviously turn its head again if we argue jury instructions, there's a pertinent case from the Virginia Court of Appeals, which is the Howard versus Harris case that came out in 2024, where the court essentially observed that the evidence at the trial court level was actually sufficient for a gross negligence finding. And they observed sort of this circumstance in which an officer had cuffed somebody and therefore exercised some care, but that in and of itself didn't amount to this scant care requirement or scant care language within the Elliott case, which preceded or predated this. And I point that out because it has a great recitation of circumstances in which gross negligence may still be found in circumstances if the jury were to even interpret the conduct as exercising care in the beginning. And that's a jury question of whether what Dr. Parker did was a demonstration of care in any regard. And I'd point out to the court that there's a case, Chapman versus City of Virginia Beach. It was Mr. Bright's case. He'll tell us about it later, in which the question was, and the instructions I think will be appropriate to the jury, about you can have multiple instances of simple negligence that amount together to gross negligence. And if nothing else, even our view is each act of a firearm on campus, which they claim is unforeseeable, and yet their handbook says weapons on the property, meaning they're foreseeing a weapon on the property. Each instance in which it wasn't addressed and gotten to the bottom of by Dr. Parker is evidence of gross negligence and indifference. But as Dr. Shufflebarger testified to, our expert, ultimately in culmination, it is absolutely shocking. It's absolutely shocking, the facts of this case. And she used those words, which are words that are parroted by the Supreme Court and the courts as it relates to instructions, whether the conduct shocks the conscience, but is somewhat less than reckless indifference, which is sort of how the courts quote that language. And so, for the reasons stated, Your Honor, I think we've demonstrated sufficiently at this stage for a jury to determine the finding of the assumed duty of care. The assumed duty is recognized under the law, as Your Honors previously articulated, and that the evidence before the court is sufficient to demonstrate that there's gross negligence.
Thank you. All right, the issues that have been raised are issues for the fact finder, which in this case is the jury, to decide. At this time, the court finds that there is sufficient and credible evidence that the defendant assumed a duty of care, breached that care in a grossly negligent manner, and that breach was the proximate cause of the plaintiff's harm. That will be all for the jury to decide. I deny the motion to strike. All right. Yep. All right. Having said that, you said you have one witness ready, or did you need to check if that
Let me
witness?
check to see if they're present. They should be here. It would be Deputy Thomas Blythe. Let me check. Right.
He's here.
He's here. All right.
All right.
Bring in the jury.
Your Honor, before you do that,
Uh-huh.
I have a motion with regard to Blythe.
Oh, that's
Blythe.
right. Okay, I apologize. You did warn me. All right. Go ahead.
And I thought we should do it before the jury.
Yes, sir. That's fine.
Well, Judge,
Corporal Blythe.
I've received notice of this.
He's
Just
it's
found
a
out that you're
trial.
calling him as a witness. Yesterday, he represented to the court that he wanted to call Officer Corporal Blythe for purposes of impeachment of a witness who has testified to an inconsistent prior statement. That's what he said yesterday. He did not release Blythe. He's now bringing Blythe back. He represented to the court that the purpose of this corporal testifying was to say that Amy Kovac had said something differently to him. As the court is full aware, Rule 2-613, prior oral statements, and I have seen this in a number of cases, the only way you can impeach Ms. Kovac from a prior inconsistent statement is to have presented, under 613, that statement to her, let her explain it or not, and then if there's an inconsistent statement, then you can question her credibility. That was not done, and therefore we don't believe, if that's the purpose of Blythe, then he cannot testify because they did not follow the process or the rules. Hearsay, one, secondarily, but 613 would specifically bar it, as would the Rule 403, 8.0 and 403.
All right, so is that your intent?
There's twofold intent, Judge. There are some statements that would otherwise qualify as hearsay if offered for their truth. One purpose would be for impeachment, but I understand the arguments are well taken.
Thank you.
By Mr. Bright. But the evidence, the law in Virginia, you can also use third-party witnesses to impeach by contradiction. They can testify to what another person said. They can then call Ms. Kovac again in rebuttal. They just need an opportunity for cross-examination. That is all that the rules require. So I would push back on that. Secondarily, Judge, I think there are additional statements on those videos that show her state of mind. And it is relevant for the jury to see that, because although she makes statements, they would not be offered for their truth. They can show and demonstrate to the jury what she was thinking at the time she was investigating the events leading to the shooting. The jury needs to see this to determine how to assess the material facts in this case. It would be fundamentally unfair to deny them this opportunity. I would suggest that the court, these are like 11-second clips, 20-second clips. Can I show them to the court? We can view them and you can make that call.
Well, I think we, as we talked about previously, allow him to voir dire the witness. I think I've got to hear everything that they want to try to do, and then I can rule on it question by question. So.
Live in front of the jury?
No, right. We'll do that before we
Right.
call the jury
Well,
in.
procedurally, we have a problem. Can't impeach your own witness, can't do it.
And two, obviously the purpose, as he stated yesterday, before he read the law, was I want to impeach her for a prior inconsistent statement. So now to come forward with a new theory, we've got to understand the context and her state of mind. The state of mind is to ask her on the stand, not to ask a videotape for Officer Blythe.
Well, I've got to see it first, and then I'll hear arguments. So I think we need to proceed in that fashion.
Thank you, Your Honors.
All right.
Call Deputy Blythe. Judge, do you want me to just direct from council table or the rostrum?
No, do it from the the middle there.
Pardon me.
No, he remains sworn in. I'll ask him that first thing. Corporal Blythe, you remain under oath.
Yes, sir.
Thank you.
Just a moment, Your Honor. Let me just retrieve my minutes. Good morning again, Deputy Blythe.
Morning. Or afternoon.
Afternoon, rather. Deputy Blythe, you recall yesterday you offered testimony about your response to the Richneck shooting on January 6, 2023, correct? And you recall you testified that when you arrived at the school in response to the reported shooting, you encountered some of the staff and teachers there, including Dr. Ebony Parker, as well as the reading specialist, Amy Kovac. Do you recall
Yes.
that? And I believe your testimony yesterday was that in the course of your encounter with those folks, Ms. Kovac spoke to you and told you about what happened leading to the shooting, right?
She did.
At the time you were speaking to Ms. Kovac, were you equipped with your body-worn camera?
I was.
And did it record your conversation with Ms. Kovac?
It did.
And would you recognize that video shown to you again?
Yes.
Brian, if you could please display Defense Exhibit 57A8 for Mr. Blythe.
He had something in his pocket. I said, you keep him in your eye. You know, and I went to hold my AP.
Pause the recording.
You know,
Your Honor, can you see the recording?
Yeah, I can see it. I couldn't really hear it great.
So I would just start back from the beginning, and could you please play it for the benefit of Deputy Blythe in the court, please?
he had something in his pocket. I said, you keep him in your eye. You know, and I went to hold my AP. And, you know, just a mess. And we were just watching him. And we thought if anything was a toy.
So, Judge, from an evidentiary.
Right, so hold on one second. Hold on one second. Is there any objection to that?
Yes, Your Honor.
Okay, and what is the objection? If it's the same one as before, I just want to make sure we're all on the same page.
Well, first of all, he secondarily indicated that it was for state of mind. Amy Kovac's state of mind is not relevant for purposes of her statement. I stand on 613 in that she was not presented with a statement, and so if she wasn't able to explain her statement, it is an extrinsic evidence to impeach, which is not permitted under 613(2), and her state of mind as to what she said is not relevant for her understanding.
All right, do you have a response to?
And the other comment, when I missed it, she said, "We thought," in that statement that we just heard. We don't know who we thought and what the timing was for purposes of the we and who said what to whom. And so for multiple reasons, it's not proper, it's speculative.
All right. Do you want to argue?
Yes, Judge. First, with respect to relevance, Amy Kovac's state of mind is relevant because we will have an expert that will testify for the defense, and it will be well established in the evidence that in assessing whether, how, and when to respond to a reported threat, an administrator needs to consider the subjective independent assessments of their subordinates. And so if Amy Kovac has come here and told the jurors that I was banging on this administrator's door, I was telling her, this is a gun, this is a legitimate threat, you need to act now, and yet she has denied, she's maintained that, look, I was telling her and she was not acting. This is someone who's the crux, a crucial link in the chain of conveying the information from the people on the front lines to the administration. It's not just a credibility issue. It's not just offered just to impeach her. It does impeach her. It is inconsistent with what she testified to previously. She denied in her testimony. She said that I subjectively thought that this was a toy gun. Yes, but I never told that to Dr. Parker. And here, number one, she does on this video say, in fact, she heavily implies, if not expressly says, I told Dr. Parker, quote, he had something in his pocket. I said, keep him in your eye, you know, and I went and told my AP, you know, this, and we were just watching him. And if anything, we thought it was just a toy. She's saying in the context of reporting to the assistant principal, she told her that they thought, if anything, it was the toy. The jury, seeing that evidence, can put two and two together, and they can infer, it's a fair inference from that evidence, that what Kovac was saying to them at the time of the incident was, me and Zwerner, or another third party, were watching JT. I went to report what we saw to Dr. Parker, and I let her know we thought, if anything, it was a toy gun. That is significant evidence. That is something the jury should hear. I understand that ordinarily, oftentimes, when you impeach with a prior inconsistent statement, it is typically done right there on the stand when you confront that person. But all they need is a fair opportunity for cross-examination. There is nothing here where they have an opportunity to call her as a rebuttal witness, to bring her up on the stand and explain it herself. There's a risk there. She could be subject to cross-examination again, but that's not my problem. And also, the defense has no obligation to disclose the purpose for which it's offering its evidence in advance. We can offer it for multiple purposes. It is relevant. Her state of mind demonstrates that this is the lady who's banging on the door saying gun, 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 and now she is telling there on the scene in clear digital evidence that the jury can see that she's saying otherwise. She's saying, I thought this was a toy gun. She minimizes the threat. If we take that away from the jury, we don't know what the outcome is going to be. This is significant. It would be prejudicial. It would not be harmless error to exclude this.
But can't you call her yourself? She's still a subpoenaed witness in the case. And then I think for impeachment purposes, you'd have to ask her if she said that or not. So I don't think it comes in under impeachment at this time. Did you have state of mind response to that?
Well, what he just said proves why it can't come into evidence.
At this time.
Period. First of all, he's failed to give the opportunity for the witness to explain herself. But what he now wants to use is the jury can infer that this video statement that was done after the fact to the officer must be what she told the defendant. And they should be able to infer that. Let the defendant take the stand and explain what she heard or she didn't heard. You don't get to put on an officer in a videotape when you fail to do it in the proper cross-examination process to allow her to explain herself, and then use we and inferences without the defendant taking the stand and say, this is what Kovac told me or didn't tell me. Now they're trying to infer stuff from a hearsay statement. Can't impeach your own witness. If he puts her on the stand to ask her, he cannot impeach his own witness.
No, I completely agree. I'm not
And
going
so
to
how does he come up now with another officer with a videotape to try to impeach her with extrinsic evidence, which is not allowed under the rule, then try to come up and say, hey, you get up on the stand, I want to impeach you by your prior inconsistent statements, which you can't do. Put the defendant on the stand and ask what was said.
But
That's how you do it.
But doesn't the exception for hearsay, which it is, state of mind, that can be for both witnesses, plaintiffs, and defendants? Isn't that true?
But it's trying to keep Mr. Binyazin from knocking me over. But the state of mind here is not the state of mind of the discussion with the defendant when the evidence was coming through as to whether or not there was a gun threat. That's what you said on the stand. And this is 218, so we're way past the shooting and way past, hours past, when she spoke to the defendant.
All right, so I'm going to sustain the objection on impeachment, but I'm overruling it as to the existing mental, emotional, or physical condition, state of mind, Rule 2, 803, subsection 3.
Your Honor, may I just address that for a moment?
Uh-huh.
The then existing state of mind exception, which is 803.3, applies to the then existing state of mind of the individual making the declarant statement. The issue here is that there is case law that demonstrates that if the declarant is attempting to demonstrate the state of mind of someone who is not the declarant, it is inadmissible for that purpose. This comes up in circumstances where people opine or testify that we had a plan to do X, Y, Z. And that is offered in those contexts to say we had a plan, as in that's our state of mind, to do something in the future. But the issue here is the we, as is reflected in the statement, is an attempt to reflect the state of mind of the other in this context. If it was I, Miss Kovac, thought it was a toy gun, different. We agree. 803.3 might apply in that context. But they've told the court that the only relevant purpose is not whether Amy Kovac thought it was a toy gun. It's that we can infer from the statement that somebody else thought it was a toy gun because it goes to their state of mind. And that is explicitly impermissible in 803.3.
Well, we can give the jury an explanation, if there's no other way that this comes in, that this statement only goes to Ms. Kovac's state of mind.
And in that case, I think the exception might apply, but the question then becomes, if this is only being offered for the state of mind of Ms. Kovac at 2:18 p.m. on January 6th, what is the relevance of her state of mind at 2:18 p.m. on January 6th? If this was a recorded statement of Ms. Kovac using their words, hindsight 2020, if this was a recorded statement of Ms. Kovac at 1:40, at 1:45, at 1:55, before the shooting took place, and she's expressing her state of mind in those contexts, then her state of mind may be relevant to what ultimately occurs. What we're now talking about is trying to say what her state of mind was at 2:18. Let's then say and infer what it was from that based upon an undisclosed period of time. And then the question is, how is that even relevant if it's at 2:18?
Here's the statement. It's then existing statement.
Correct. As pointed out, the rule by title is then existing. Then as in 2:18 p.m. In the evidentiary, look, this is when they make fun of me about my nerdiness of evidence rules. Ultimately, it's all about reliability. And the issue with reliability when we talk about people talking about prior states of mind is that we've lived life for 2 hours. And it is speculative, even Your Honor sustained an objection earlier in this trial when we said, well, you would have done or you could have done different. And that's because we would have or we could have are all questions of speculative time frame, even if it's our own being. And so the then refers to then, 2:18 p.m.
Such as motive, intent, or plan. That's what's used.
Judge, if I could just respond to a few quick points.
You may.
Just revisiting the relevance issue briefly. I know this is not the crux here, but the fact that opposing counsel is vehemently opposing the introduction of this highly probative evidence demonstrates its relevance. They don't want this to come in because the jury needs to hear about it. Regardless of that, in addition, I think that the jury, when they watch this video, they can assess Ms. Kovac's demeanor, they can see how she's responding to the deputy's inquiries, and they can assess and weigh her credibility just by watching the video and seeing how she reacts and responds. This is the crucial witness that the jury needs to decide her credibility. Yes, prior inconsistent statements is one piece of that, but it's also just watching her demeanor. They talk about that in appellate law all the time. You can't do that just from a cold record. The jury has to do it, and the jury can't do it without watching the video.
But you're saying it's trying to impeach her. I'm not going to allow you to do it this way. So I'm going to agree with plaintiff's counsel that her state of mind, I would allow it in as a state of mind, but her state of mind isn't relevant at this time. And so I'm going to grant the objection, sustain the objection.
Well, Judge, I wanted to be clear. I was addressing the impeachment argument, but I will offer it for a dual purpose. That is why I offered it. I had two bases to offer this. One was to impeach and one was to show her state of mind. I agree with the court that it is relevant, especially it's conditionally relevant at a minimum because we'll have an expert to explain this to a jury that Ms. Kovac's subjective state of mind mattered for the expert to assess, for Dr. Parker to assess.
But I haven't heard that testimony yet. I haven't heard your expert yet. So maybe it comes in at that time. It just as the beginning of your case. I'm not going to do that.
Then I would ask the court to reserve ruling on this at this time.
At this time. I mean, you have other ways you can try to introduce it. I'm not disagreeing with you that way. It's not forbidden. If there are other ways to introduce it, I'll allow you to do that. Or if it becomes relevant.
Thank you, Judge. I appreciate it.
All right. So objections noted with leave to try to get it in later. All right.
Judge, for purposes of expediency, let me just proffer, if I may, the contents of the other video. I think these are similar issues that we would grapple with.
Yes,
is there any objection?
My decision.
Is there any objection?
I object to everything about this witness and all the video tapes.
Okay.
I think we should play the tape.
Okay.
Brian, please queue up Defense Exhibit 57A. A8, excuse me.
You did 8.
Oh, pardon me, A10.
But we did check his bag, like what we thought, you know? And she didn't say anything back to me like he moved something back from his pocket. Like, I mean, again, so a 6-year-old.
So you can see clearly, Judge, going in reverse order. Again, it's a 6-year-old that goes to the heart of Amy Kovac's state of mind. At the time, shortly after this incident, she's telling law enforcement, someone who has authority someone who you don't want to mess with, that you want to be candid with, especially when she's taking ownership of investigating this and saying, I was the first one in the room. She's talking to this person. The jury can see this is her live when she's telling people for the first time what happened. And she says, it's a 6-year-old. It's a 6-year-old. That's showing her state of mind. And it will be conditionally relevant at a minimum when we put on our expert to explain, yes, the demeanor of the reporting parties is a factor for the administrator to assess whether, when, and how to respond. Let me just make this concrete. If Kovac comes into the office and says, there's a gun in the building, we saw it, you need to go right now, get up right now, get out, get over there, is materially different from going into the office and saying, I think it's a toy gun, he's a 6-year-old. Her demeanor is what matters. And that's something that Dr. Parker had to consider. And it is part of the heart of this case. So I think it goes to the...
There's just not enough, you haven't put on enough of a case to make it relevant at this point in time. I'm not denying that at some point it could be relevant, but at this time it's an improper impeachment, and at this time it's not relevant. Did you have anything else you wanted to add?
I don't, but
Okay.
there's someone at my table who might.
Your Honor, I think it is flawed from the outset. And the reason it's flawed is the argument now that the demeanor of the witness is pertinent to the jury because it goes to the administrator's state of mind of how they subjectively interpreted the demeanor of that individual when they made the report. How are we to say that her demeanor at 2:20 p.m. is the demeanor at 11:40 p.m. or 11:50 p.m.? And so, in fact, it is the opposite is true, which is that if Your Honor permitted this for that purpose, which is to demonstrate the demeanor of a witness, so that defense counsel can argue that that demeanor reflected the demeanor at the time that the reports were made, that is flawed, ab initio.
I understand, but they may be able to put on a case where it does either become relevant or impeachment, and we'll take those up separately if we ever get there. So I'm going to grant the motion on those grounds at this time.
Thank you, Your Honor.
Okay. Any other questions for the corporal at this time?
At this time, thank you.
Okay, and obviously he's to remain under subpoena, correct?
Yes, but I'll be in contact with you.
Okay. All right, so obviously the jury's not here, so that's why we did this. So I'm not permitting your testimony on those grounds right now. However, I do, you are still under subpoena and subject to recall, so please don't discuss your testimony. And until then, or someone tells you that you're released, you can't talk about it, okay?
Yes, sir.
Thank you very much for being here again. All right. Do you have any other evidence you can present this afternoon?
No, Your Honor. This was our sole witness. We did our best to try to recruit some others, but we've also consolidated our case. I will confer with lead counsel on this and we'll make a decision.
All right. So you want me to release the jury and then you talk and then I'll come back out, or we just ending for the day once?
Well, you had indicated earlier this morning that the 7 o'clock, I read your comments to suggest that the 7 o'clock rule of exchanging witnesses wouldn't apply since we came to court today, having advised them on Monday that we'd be finished Wednesday afternoon or Thursday morning with only one witness. So we don't want to wait and find out what we're doing tomorrow until 7, since we waited last night to find out there was one witness who wasn't even going to get on the stand. So we'd like to know if there's a time that we could get it by 4, or wait right here and do it and say, tell us who your witnesses are tomorrow.
All right, so you're asking for some more time, is that correct?
Just confer with counsel. I can do it through.
And as I said, I can bring the jury and release them, then step out, and then I can come back. I'm fine with that. Me getting up and down isn't a problem, it's them.
Yeah, I would let them come and go.
Right.
My only concern with that, just to flag it, is if they're released and they have no evidence tomorrow, and they're being asked to come back, and then we just release them again tomorrow.
Right.
That would be my only hesitation. That's your Honor's, this is your courtroom, this is how you handle it. But if their position after conferral in 20 minutes is we don't have any fact witnesses, and we have no evidence, I mean, we take issue with that administratively.
Right. I understand.
But we understand that the experts were scheduled for Monday. I wouldn't want the jury to come back tomorrow morning and
For nothing.
Yeah, let them wear their costumes and be with their family if that's what's going to happen.
All right, I understand. All right, I appreciate that approach then. How long are you going to need to discuss strategy, I guess, or figuring out if we can call witnesses tomorrow? And I want you to say, I am sympathetic to you having set up your experts on Monday. I have no problem. We've discussed that the whole time getting ready. But I would like to do something, if we can do anything, tomorrow, and whether or not we need the jury. I certainly, if I do give you, if we don't do anything tomorrow, I want jury instructions worked on. That would be, okay.
I think we could have about 15, 20 minutes.
All right, I'll grant you that, and then I'll just go address the jury that they're not going to be needed for the rest of the day. We're determining the schedule from this day forward, and we'll ask them to be patient with us.
Thank you, Judge.
Okay. All right, court will be in recess for hopefully 15 minutes.
Please
Thank you.
rise.
witnesses today for the defense, but I would propose we reserve tomorrow, we release the jury tomorrow, we can handle jury instructions, come back Monday and address experts. But I also ask, given the court's ruling, leave to potentially call Deputy Blythe to establish the requisite foundation necessary to get that evidence in.
Okay. All right, did you want to work in your offices or on the jury instructions or here?
It's a good question.
Okay.
The
I try to ask good questions, I promise.
That's a great question, honestly. I'd be comfortable doing it by remote with the court and with counsel. The thing that I will sort of flag is that there are going to be issues as it relates to the substance of the experts, obviously, which were motions in limine. So we may, if we have time, do that tomorrow, and to the extent maybe they're available. I haven't talked to them about this, so I don't want to put them under the gun. To the extent they're able to appear via Zoom so that we can have that proffer, that may be helpful too.
Okay.
Other than that, we would take issue with fact witnesses being called Monday in light of the delay, and we would ask that anyone that is under subpoena, that is not being called, be allowed to be released. There are folks that wish to be in the courtroom to observe some of these proceedings, and they haven't been able to do so because they're still under subpoena and haven't been notified that they're going to be called.
Your Honor, I don't know if my experts are available tomorrow for a proffer. My understanding is the issue with Dr. Klinger, who matches Dr. Shufflebarger's, we've worked that out. I can't represent to the court that there's only one other expert at issue, and that's Dr. Means, and I can't represent that he's available tomorrow.
Yeah, I mean, it's going to make for a frustrating Monday, but I understand.
Yes.
We could, and I'll alert the court that there's a forensic psychologist, I think, is something that we could take up without a proffer. We don't think that the witness should be permitted to testify in toto, but we don't have to take that up today.
Right. Yeah,
That's
I think it's going to be a Monday problem, the way that we had planned this. And as I said, we did the best planning we could, so.
And I'm not aware of any motion regarding Dr. Hagan, the forensic psychologist.
It wasn't challenged. It was not challenged in the motions and on the
It is being challenged.
All right, well, I guess we'll just have to take that up when we can on Monday, I think. I don't know how else to do that. All right, so I can be available by Zoom, obviously, or WebEx tomorrow up to a certain time, seeing as it's Halloween, and to take care of any disputes. But I would appreciate a set of agreed upon instructions, one set of plaintiffs offered and objected to, and defense offered and objected to. For at least I can get myself and my law clerks who have abandoned me to oh, there you are, to start looking this weekend at some of those issues. So I would appreciate that.
We need to rest in front of the jury.
Okay. Yeah, because we got to bring them in and talk to them anyways. All right, so agreement that we'll all be available by WebEx tomorrow. I'm going to release the jury for today and tomorrow to report Monday at 9 a.m. And jury instructions, hopefully the three sets of instructions by 1. Is that a possibility? All right. All right. Is that agreeable? All right. Very well. No, I'll tape it. I can tape it on the record. So could you give me your link? Right. You can have 1 o'clock. Yeah, so why don't you write your, give me my card. Okay. Or give me my card, that's fine too. And I'll just text you my numbers.
Nine jurors in the box.
Thank you. All right, ladies and gentlemen, we have a motion that's going to be made by the plaintiff in your presence, and then I'm going to address you.
Your Honor, plaintiff at this time rests their case.
All right. The plaintiff's evidence has now concluded, so we are going to move on to the defendant's case, but we are not going to do that until Monday morning at 9 a.m. So you are done for the day. You are also done for Friday. You can get caught up with your families and or work, whichever order you want to put those in. I leave that up to you. And also enjoy Halloween as well. So, as always, and it is very important because I'm not going to see you for 3 days. Ladies and gentlemen of the jury, we are now recessing for our break until Monday at 9 a.m. when I ask you to be back in the main courthouse to check in. During this recess of this trial, you are not to begin the discussion of any aspect of this case. Upon your return, you are requested to go immediately to the main courthouse, and then you will be brought down here. You are not to engage in any conversation with any of the parties, the witnesses, the attorneys, or any of the spectators, including the media. You are not to go to the scene of this case or undertake any independent investigation, including the internet or other electronic means. No one should approach you and discuss this matter, and you should not remain within hearing distance of anyone discussing any aspect of this case. That includes your family members and loved ones, and tell them you are, by order of this court, not allowed to discuss or be within hearing of any discussion of this case. Of course, as I've indicated, this includes viewing any newspapers or television or listening to the radio. Watch a lot of sports or scary movies. Those are your two choices. You must also leave your notepads and any notes that you have taken with my deputy. He will make sure no one looks at them and they remain solely in our custody. If you are approached by anyone concerning your jury service during this trial or this recess, make that fact known to my sheriff or me. We will take it up at Monday at 9 a.m. Thank you for your patience with us. You are excused.
Please rise for the jury.
Then any witnesses you are able to release, I would appreciate you doing so, that they can either come back or be released from their witness list. Anything else to take up?
We okay to leave technology and stuff all
Absolutely.
looked up as it is?
Yep. No problem at all. Anything else from the defense? All right, I will hear from you tomorrow. Thank you all very much. Court is in recess.